Well, hello everyone, and welcome to Uncivil Law. I'm Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. We are continuing with our coverage of the Chad Daybell trial. Chad Daybell is on charge for 3 counts of murder, 1 with respect to a former spouse, and 2 with respect to children of his current spouse. His spouse had previously been convicted and sentenced to life imprisonment for her part in the murder. They were tried separately because of speedy trial reasons. She wanted a speedy trial and he did not, so that required severing the trials. Due to some malfeasance by the prosecutor, the judge threw out the death penalty with respect to Lori Vallow, but the malfeasance was not deemed to apply to Chad Daybell because, remember, they are separate cases. So they effed up the Lori Vallow case, but not the Chad Daybell case. So Chad Daybell is eligible for the death penalty in this case. Lori Vallow, for her part, in addition to being convicted of these murders, is being extradited to Arizona for more counts of murder. So she's having more fun in other jurisdictions as well. They like the murders and they like the attempted murders, and they're involved in a whole bunch of shit. So yeah. So Chad Daybell's on trial, and we are in jury selection. Yesterday, we heard part of phase 1. 8 men and 8 women, as I understand it, were passed through to phase 2. I believe we are still, however, stuck in phase 1. I believe today, if I understand the agenda. So we're doing this in phases, as I understand it. So we're trying to boil down the pool, as we call it, the veneer. That's what it's called, into a smaller veneer from which we're going to ask different questions or more intense questions in a more regimented way, perhaps. So we're trying to do, it seems, if I'm understanding it correctly, it seems like we're trying to do, sort of the gross cut, for the most obvious cause-based reasons. And then at some point, we will have enough people left over that we will move into phase 2, during which we will ask more intense questions and do perhaps further cause challenges, although that isn't expected, but it could happen. And also that we will do the more interesting preemptory challenges in which the lawyers just get to throw people off the panel because they want to, as long as it's not based on race or sex. They can throw them off for basically any other reason other than that. So that is what's happening. So I'm expecting today to basically just be a repeat of yesterday in basically every possible sense. That is my expectation. We're just going to have, we went through, it looked like 2 groups yesterday, if I sort of followed everything correctly. We went through 2 groups, and it took a long time to go through those groups because we had to do a lot of individual questioning. And it looks like we're going to do more groups today. So we have 16 so far in our initial first pass pool. And we're going to, I think, go back to phase 1 and expand our pool. So that seems to be what we're doing. I'm not sure what target number they're trying to reach for the second phase. I'm not sure what number they're trying to get to. So presumably the judges announced what number they're trying to get to. So there's probably some number in mind they're trying to get to for the number of possible jurors that they're going to whittle down. So we'll see. Yeah, that's right. That's correct, David. That's a better way of thinking about it. Thank you. So it wasn't so much that they didn't screw up in the Chad Daybell case. It was just the screw up was such that it didn't unduly prejudice his rights. That's a better way of thinking about it. That's right. Because Lori Vallow was on a speedy trial clock, it had to deal with late discovery of evidence. It had to deal with late disclosure of evidence, Brady violations essentially. So the judge basically said, in so many words, that because the evidence was so late disclosed to Lori Vallow, there wasn't enough time for her defense lawyer to basically deal with the information that was provided to her because it wasn't provided in a timely fashion. And so, they can't be forced to waive their speedy trial rights. She has every right to enforce her speedy trial rights. So you can't force her to take more time. So because she's like, no, I'm not going to take more time and you can't make me. And the judge said, okay, well, there's not enough time. So there's not enough time for the defense to get up to speed on this evidence because it's late disclosed. And so I'm going to remove the death penalty as a sanction as a result. Whereas, of course, because Chad Daybell did not waive speedy trial, he did waive speedy trial the other way around. Because he did waive speedy trial, he could get more time to reduce the prejudice. So that's a better way of thinking about it. That's a better way of thinking about it. So a fair correction, to be sure. I can't see there being any evidence that would possibly be exculpatory. You possibly misunderstand what it means to be exculpatory in some sense. And in the same way that it is a bit of an error when people say, what proof do you have that so-and-so happened? That's a bit of a mistake, because the question isn't proof, the question is evidence, and evidence only needs to make something more or less likely. It is rare that there is like a single piece of evidence that just, says everything you need to say. And it's also rare that there's not other evidence that somehow contradicts that or ameliorates it in some way, particularly in a death penalty case, as you would imagine, because you're dealing with not only the guilt of the person, but you're also dealing with any evidence that would suggest against or would be mitigating against a death penalty sanction. So people somewhat err, to my mind, by saying, well, there's no proof of this. And it's like, that's not really how that works. The proof is based on the consideration of all the evidence together, whether or not you ultimately prove your case, whether or not you ultimately prove it beyond a reasonable doubt. It's very unlikely there's a single piece of evidence that does that. And it's very likely there's evidence that somewhat suggests against it. So yeah, I think you somewhat perhaps misunderstand, because is there evidence that, like, in terms of, is there a piece of evidence that just proves that she didn't do it? No, probably not. But that's not the point. There's evidence that might suggest that she didn't do it and that she might not be worthy of the death penalty, because that's a calculation at the end of the day, right? Even if she's guilty, you still have to reach the calculation based on the aggravating and mitigating factors, whether or not she's worthy of the death penalty. And even if the evidence in combination would reach the conclusion she's worthy of the death penalty, because you denied the defense the mitigating evidence, which they're entitled to under Brady, they can't sufficiently prepare for it, and so you have done it bad. So whether or not that sanction was warranted is a whole other set of questions. So I don't necessarily blame you if you think that the judge overreacted by getting rid of the death penalty. So that you can certainly criticize the judge for getting rid of the death penalty because the sanction was not warranted by the breach. I think that's a perfectly reasonable conclusion. But I think the premise that you were working from, or appeared to be working from, that, well, there's no evidence that could, prove she didn't do it or mitigate. I think that's the wrong premise. That's not what we're looking for. We're just looking for any evidence that suggests that she didn't do it, she's not responsible for it, or in any sense suggests that she's not worthy of the death penalty. That's any evidence, which by definition only has to make it to any degree more likely, at all, even a little bit. So it might not do very much for you, but if it does it at all, that's legally evidence by definition. Yeah. So I think that that's a better way of thinking about it. I was thinking about this recently because I was watching a stream that was being done by, I think it was an old stream. It might have been a year or two ago. I don't know, but it was popping up in my feed. I was watching a stream of Asmongold, who was doing this critique of this person who was suspected of cheating in gaming. She did a blindfold run, and there was a person who did a review of it who put together factors that could be seen from the video to suggest it wasn't really a blindfolded run, right? She had a blindfold on her eyes, but she wasn't really blindfolded. And there was evidence to show how to do that. And one of the gamers moderators, was a woman gamer, as it happened to be, but one of the woman gamers moderators came on and said, well, there's no physical proof that she cheated. And I was thinking to myself, that's not really asking the right question. That's not really asking. There's no proof that this happened. It's like, that's not quite right. That's not how that works. It's not, yeah, there's no evidence that proves that. That's, yeah, find me, there. It's very rare there's a single piece of evidence that proves. That's unusual. There's evidence that suggests. And, you know, so it's a bit of a mistake to say, well, this proves or disproves it. That's not typically how that works. So I hope that explains it and provides a better view of the thing. Yeah, I guess I mixed up exonerated with exculpatory. Yeah, there you go. Yeah, there you go. Yeah, yeah, there you go. So yeah, that would exonerate her, probably not, but that's not the point. Exculpatory evidence is any evidence that suggests to any degree that she didn't do it, she's not responsible for it, or otherwise suggests that she's not worthy of the death penalty, since that's a jury question. That would be in the definition of exculpatory. So yeah, and so they effed around and found out, I guess, a little bit. But I think it is, well, I think it's very, very reasonable to criticize the judge for the determination of the sanction, that it wasn't necessary for that particular sanction. I think you can make that conclusion. But, you know, it's helpful when you're making such a conclusion to factor in the correct, you know, facts when you're making the ultimate decision. So I hope you don't mind the correction. You know, trials are about building a wall, and another brick in the wall, as it were. So any brick will be fine. Or maybe it's a stone wall, and maybe a stone wall is a better analogy. So any pebble will be fine. Any pebble will be fine, because it helps to build the wall, or not, as the case may be. Yeah. Good morning, Sarah. How are you doing today? I'm doing great today. Life is good. I feel awesome. I'm in good spirits today, and I'm glad to be with you. And I'm hoping that that feeling of being in good spirits will continue to last for some time. That would be nice. I'm just waiting on the judge, by the way. I'm on their YouTube page just waiting for them to start, so we'll get there whenever they get there. Yeah. 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 I'm happy to provide these, you know, corrections. You get ready for more reading time? I'm ready too. I've charged up my Kindle and everything, man. I'm ready to go. Yeah. Also, I think, you know, in balance, probably. Well, first of all, Idaho hasn't executed anyone, I think, since 2009. So they don't seem to be really in a rush to do it. And Lori Vallow, for her part, was mentally disturbed. Well, I don't know if disturbed is quite the right phrasing. She was mentally compromised is better. She had, on a number of occasions, been ruled incompetent to stand trial. Now, of course, that's something that can change because competency can be established or not, right? It's not the same thing as being incompetent at the time of the offense, which is another question, right? Whether you're incompetent or not at the time of the offense is going to be fixed because the event is fixed in time, right? It happened. Either you were competent at the time or not, as opposed to being competent to stand trial, which is, of course is more of an ongoing thing because the trial can, at least in principle, happen any time. And so if you're incompetent, we can restore you to competency. Maybe you can become competent. But seeing as she was on the edge of competency, as it were, if she had been given the death penalty, it would have been tied up in appeals until the end of time. So, yeah. So it was probably for the best, all things considered, that the death penalty was not an option because it makes things a lot cleaner. I take no particular position on at this time whether or not Chad Daybell should deserve the death penalty or not, by the way, incidentally. I don't really know. I'm very interested on it on a pragmatic level because we have never as a channel done a death penalty case. This will be our first death penalty case we've ever done. And it'll be very interesting to try to figure out as we're watching the evidence and trying to figure out whether or not this person is worthy of death. You know, whether or not they've earned death. And, you know, that's a very interesting question. So, yeah. Yeah, that was evident by her statement to the court before being sentenced. That was one of many clues. I agree. True crime becomes an uncivilian at the $9.99 tier. How very generous of you. Thank you for joining at such a high tier. We do really appreciate it. How's my case going? It's going fine. We did a lot of legal research yesterday, going through law reviews, and we have quite a lot of, I have something like 24 or 25 pages right now of pulled quotes from various law reviews, court cases, and other things, right? So I have 24 or 25 pages worth of things to use. And hopefully today, I'm going to finish up like reading the law reviews is sort of my goal for the end of the day. So I want to read through the rest of the law reviews. And then starting tomorrow, I'd really like to start writing and start putting this together in some sort of coherent fashion. So that's where we're sitting, and I'm thrilled. Your final for criminal law and procedures of position on the death penalty? Cool. My view, you know, here's my view, which is perhaps an unusual view. So I share it with you, perhaps because maybe you haven't heard it before, and maybe it will inform your paper and make it better. So let me share with you my view. My view is that life without the possibility of parole is a bit of a coward's sanction. Okay, so we're going to work from the premise for the exercise because we're going to do this in principle. Okay, let's do it in principle. Let's assume the person is in fact guilty. All right, let's assume they are in fact guilty, and let's assume they're in fact guilty of a crime for which life imprisonment without the possibility of parole is a valid and just sentence, which, you know, you don't need a lot for that because a garden variety murder can get you there. Not all states, but some states. You know, just a garden variety murder, you know, no particular complications, can be sufficient to get you life without the possibility of parole. So we're going to assume this person is in fact guilty. We're going to assume they're guilty of what we'll categorize as a garden variety murder. And we're going to assume that life without imprisonment, life in prison without the possibility of parole is a just sanction for that, which, you know, is not asking a lot. That's not a lot of assumption, because that definitely describes a whole bunch of cases, right? This isn't some theoretical case. That's a lot of cases. There are a lot of cases in which the evidence against the person is incredibly strong. There's a lot of evidence against the person which would suggest life without the possibility of parole, right? I think we can all get there. My view is that not giving the death penalty is a bit of a coward's solution, because it feels like in such a situation, you don't really have the courage of your own conviction, because you have apparently reached the conclusion this person deserves to die. Now, you want them to die in prison, and you want them to die from natural causes. So you want essentially the Grim Reaper to do your dirty work for you. That's my view. It's like, I have made the determination this person deserves death, but rather than me, pulling the trigger because I'm a bit squeamish, I'm going to pretend that I'm not really responsible for their death. I'm going to pretend I'm not really responsible, because what I'm going to do is I'm going to lock them into a cell, and they're just going to be there until the Grim Reaper does it for me. So I feel like in a lot of ways, life without the possibility of parole is just a coward's solution. Because if you really believe this person deserves to be in jail without the possibility of parole, you know for an absolute certainty that death is the thing that ends the sentence. That is what ends the sentence. Death is what ends the sentence, which is also true in the death penalty. Death is also what ends the sentence. In both cases, death is what ends it. But you don't have the courage to actually pull the trigger. You don't have the courage to actually swing the sword. If we want to go back to Game of Thrones for our inspiration, the man who passes the sentence should be willing to swing the sword. But you don't want to do that. You want to pass the sentence, but you don't want to swing the sword. You want to have the Grim Reaper do your dirty work for you, you pussy. So, like, what do you really believe here? What do you really think? You know? So, yeah, it's like life imprisonment is a pussy solution. You know? Because, like, yeah, you're unwilling to exact the sentence that you really think this person deserves. So it's like, yeah, okay. That's what I think. So that's one of the reasons, incidentally, I don't think the moral case against the death penalty is as strong as people think it is. Because people are like, well, you know, the death penalty is irreversible. I'm like, well, so is life imprisonment without the possibility of parole, by the way. And for a case where they're actually guilty. But, you know, your concern, I don't really think stems from the fact whether they're actually guilty or not. Your concern really stems from the fact you don't want to pull the trigger, you pussy. So, yeah. Death row such more expansive? Yeah, but this is a theoretical exercise, at least to some degree. Right? So, you know, we can ignore due process considerations for a moment because we know for a fact this person's guilty. We've established that in our hypothetical because it's a hypothetical world. We know this person's guilty. So if we know the person's guilty, then, like, seriously, why aren't you taking him outside the courthouse and putting a gun to his head and pulling the trigger, like, right away? Why not just take him out into the courtyard and blow his head off? Too much? Too much? Hey, you're a bunch of pussies. You're a bunch of pussies. That's how I think about it. You know, it's like, oh, I'm just going to lock you in a box and pretend I'm not responsible for your inevitable death. You know, so yeah, I don't think so. That's an argument against the death penalty in principle. And so, like, some people oppose the death penalty even in principle. That's why I give the hypothetical. So now if you're like, okay, now I'm going to throw in pragmatic solutions, like we don't know if the person's really guilty or something, then okay, now we have a different hypothetical, right? Because some people oppose the death penalty even in principle. And I'm like, okay, so even in principle, if you know the person's guilty, and you know that for a fact, because it's hypothetical world, because we're talking about principle, if you know for a fact this person's guilty, you don't think they deserve death? Right. But you're willing to lock them away for the rest of their life. Right. Okay, I think you're a pussy. That's what I think. There's my take for the day. How's that for a hot take on the death penalty? Good times. Yeah. Death can be viewed as an escape. Okay, well, I suppose that's another perspective. If you have that perspective, if you believe life imprisonment is the more severe sanction, okay, I suppose that's the solution. Although that seems a little bit potentially cruel, to be honest. So I would question the morality of that decision. So if your view is that life imprisonment is more severe than death, it's like, okay, the reason you presumably think that is because you believe that the prisoner is going to wake up every single day in prison and have to face the reality that there is no hope, there is no escape, there is the monotony of just every single day forever until they eventually die. I don't know, man. You could even view it as a little torturous, to be honest. Because it's like, why not just end it? Why not just end their suffering? It's like, okay, I'm going to actually put them in jail for the rest of their life because I believe it is more torturous to them, essentially. I believe it is more inflicting on their mental state. I believe it is the greater thing. It's like, okay, if that's your view, is that really a fully ethical view? Maybe you think it is. Maybe you think it is. Maybe you think the person is worthy of that because of what they've done. Maybe you think they should be forced to every day, day in, day out, without hope, without escape, look at the walls and know that there is no end except the sweet release of death that will eventually come. But if that's your view, is that really a fully moral view? I don't know, man. I challenge that. I challenge that. You know, I'm not sure. I'm not sure about that one. Yeah. Yeah. You could actually view the death penalty as merciful. I've had this thought, by the way, for instance, for myself. And it'll be an interesting exercise for yourself too, to think about it. Like if you knew for an absolute certainty that you're getting convicted and you have the choice, life imprisonment without the possibility of parole or the death penalty, if those are your only two options, which do you pick? And I don't know, man. I think the death penalty might be the preferable option. But you know, it could be just me. Aren't they isolated on death row? Typically, yes. They're very isolated. But yeah. So I have a slightly different view of death. Yeah, I have a slightly different view of death. Life without imprisonment is the coward's way out for the sentencer. So I don't think the moral case is as strong as people make it seem. And so I think the moral case isn't as rock solid as they make it seem. And yeah, and and also, like, if you're actually innocent in reality, like, which would be better to have? A death penalty? Would it be better to be sentenced to the death penalty, or would it be better to be sentenced to life without the possibility of parole? If you were in fact innocent, which would be better pragmatically? Like, if my objective is, you know, I didn't do the thing, and I'd like to be exonerated very much, and preferably let out of prison, which is better for you, being sentenced to death or being sentenced to life imprisonment? And I'm not sure it's inherently obvious either which of those cases are better, because death penalty cases, as we've been discussing, are so reviewed at every possible level. They're torn apart, like, at every possible level. So whereas other penalties are not torn apart to the same degree. So if your hope rests in you being exonerated, the death penalty might be preferable, because you know that there's a whole bunch of people who are tearing it apart every possible way to find any possible reason for you not to get the death penalty. So it might be preferable from a pragmatic point of view in establishing your actual innocence to face the death penalty. How's that for a head trip for the day? That's fun. Yeah. Botched executions are a problem. I favor nitrogen asphyxiation, which they just did for the first time in Alabama, was it? That's how I'd want to go. I think that's the best solution. Breathe pure nitrogen, and man, that's a good way to go, man. I'm in favor of that one. What's the objective? To punish the convicted or protect society? Well, there are multiple different objectives when it comes to why we sentence people to any penalty, whether it's a traffic ticket or the death penalty. There's sort of the master reasons why we do that. So the master reasons about why we punish people, like in principle, there are a couple. One is specific deterrence. We want to prevent you in particular from committing crimes. We are punishing you to specifically encourage you in particular to not commit more crimes in the future. You've gotten whacked over the head. I like to not be whacked over the head very much. You've learned your lesson. Specific deterrence. General deterrence. We're whacking you over the head as a warning to others. Hey, see what happened to this guy? Do you want that to happen to you? No. Then stay in your lane. General deterrence. Isolation. We're punishing you to keep you away from society because you're a danger to society, and we need to keep you away from the people because you're just an ongoing threat. Rehabilitation. We are punishing you to make you not bad. You're bad, and we're punishing you to make you not bad, so that when you get out, you will no longer be bad, and you will be good and able to live in society like a good person. So we're punishing you to rehabilitate you. And reciprocity. We're punishing you to balance the scales. An evil has been done. We are punishing you to balance the scales so that the evil is now in balance with whatever it is we're doing to you. And those are your reasons that you punish people. So which of those do you like and which of those you don't like goes a lot to your theory about why you about your ideas about what prison should be like and whether or not you have the death penalty or not. So how does the death penalty rank on these various metrics versus life imprisonment? How's the death penalty rank versus life imprisonment? Well, first, general deterrence. Does it have a general deterrence effect? Does executing someone deter people in general from committing crimes? The evidence on this is at best mixed. And the evidence is at best mixed that it deserves to, that it deters people in general. So we'll call it a wash. Specific deterrence. Does it deter you in particular? Yeah, it's the specific deterrence. It's great. It deters you a lot because you're dead. Isolation. How does it do for isolation? Well, again, the death penalty works much better. In life imprisonment, you're still around other prisoners and prison guards. In death, you're dead. So isolation works a lot better for the death penalty. The death penalty wins on isolation. Rehabilitation, which is better? It's a wash. Why? Because either way, you're not leaving prison. So what does it matter? Right? The whole point of rehabilitation in principle was we let you out of jail because now you're fixed. But we've determined that you're not fixable. So rehabilitation is a complete wash because we've determined you can't be rehabilitated. That was the whole point of the life imprisonment without the possibility of parole. So yeah, rehabilitation is completely neutral both ways. Either way, you're not getting rehabilitated, so it doesn't matter. And reciprocity, which is better? Well, that depends on your point of view, I suppose, to some degree. What more balances the scales? So that's a little bit more in the eye of the beholder. But yeah, those are the ways to think about it. So the death penalty works great for specific deterrence and isolation. Isolation works fantastic. It's a bit uncertain when it comes to general deterrence. Rehabilitation is a completely irrelevant factor. And so the only factor that's sort of in dispute is the reciprocity factor, which better balances the scales. So there you go. Yeah. Maybe they can help someone in prison. Yeah, I mean, yeah. I'm not necessarily opposed to public executions. The United States history is legion with public executions. And also, if we truly can't stomach it, then we're also a bunch of pussies. So do we believe in the death penalty or not? Right? So it's like, yeah, if you really believe in the death penalty, you probably should believe, I would think, in it being shown to the public. I mean, or displayed to the public, because, well, I mean, certainly the knowledge of the execution would be much more widely known. So to the extent there's a general deterrence effect at all, presumably it would have greater general deterrence because people would actually see the execution. But if you're too weak to stomach it, then you shouldn't support it. You should never get other people to do your dirty work, is a principle I believe in. Which is one of the reasons I object to the life imprisonment, because I think you're getting the Grim Reaper to do your dirty work. And I don't really like that. I don't really think that a person should ever get someone else to do something that they themselves are not in principle willing to do. If you're not in principle willing to do it yourself, then it's wrong to have someone else do it. It's wrong to outsource your ethics right? So if you're not willing to pull the trigger yourself, then, you know, fine, I suppose. But I would caution you whether or not you have fully thought through the ethical implications of life imprisonment, though. Because out of sight, out of mind, right? So that's one of the reasons you don't want to see the death penalty, because out of sight, out of mind. But if that's your problem, out of sight, out of mind, then I would also caution you to think through life imprisonment without the possibility of parole, because out of sight, out of mind. Do you really think that that's ethical? What does that mean? What does that mean to the prisoner? Is that really ethical? So you need to think through the ethics on that too, as to whether or not you think that's ethical. So, you know, I'm challenging all your ethical precepts right now. That's what I'm doing over here. Just challenging all the ethical precepts. But the Grim Reaper isn't a person. Death is inevitable. I don't really think it matters. To me, it doesn't matter. You know, I don't really think it matters. To me, it just feels like I'm outsourcing it. The fact that death is inevitable, the fact that the Grim Reaper is inevitably coming around, I mean, it's true, but it still feels like I'm outsourcing it. At least to me. I'm outsourcing it to a natural force, but, you know, it still feels like I'm being a pussy. So if you eat meat, you should be able to watch the animal you're about to eat be slaughtered. You should, in principle, be willing to slaughter the animal, more to the point. Yeah, I mean, that would be the thing, right? You should in principle willing to do the slaughter itself. That's more to the point. Just as in principle, if you believe in the death penalty, you should be willing to pull the trigger yourself because you believe in it. So I tried hunting exactly one time. I got myself a hunting license. I did hunting exactly one time. I determined I didn't like it. I didn't very much enjoy being woken up at dark 30 and then going into the woods while it was still pitch black and camping out in the cold. That did not make me happy. I was like, you know what I could do instead of shooting the deer, you know what I could do instead is I could just buy the deer from the butcher. He would happily sell it to me. But it's not that in principle I'm not willing to do it. It's just that I didn't enjoy it. But in principle, I should be willing to do it. Just as in principle, I should be willing to pull the trigger. So yeah, that would be the thing. That would be the thing. Yeah, Cammy says you're not getting someone else to do your dirty work because it's not a person. To my mind, I just think that's a conceit. I think that's a deflection. That's just me. That's just me. I think it's a deflection and a conceit. It's like that. The Grim Reaper is not a person, so it doesn't really count. I think it's a deflection and conceit, but that's just me. It feels just like a big Rube Goldberg machine, really, to me. It's like I'm not really responsible for the death because all I did was push the domino that caused the marble to roll, that caused the thing to swing, that caused the. It just feels like a big ass Rube Goldberg machine in a lot of ways. It's like, oh, I'm not really responsible because all I did was, push the domino, and 800 steps later, the death penalty occurred. So I'm not really responsible, but you've set in force a chain of events where the result is inevitable. In this case, the result is the Grim Reaper comes and kills the guy. But you're still setting that in place because, well, you're locking him in the cell until that happens. And so it feels a little bit like a deflection to my mind. But you're obviously able to disagree. I'm just explaining my philosophy on the issue. It feels a bit like a deflection, and it feels a bit like a conceit to say that it's not a person, and therefore it doesn't really count. At the risk of maybe a more extreme example, if I go tie you up and leave you on top of the volcano with full knowledge the volcano is going to explode, it's like, oh, well, I'm not really responsible because the volcano was going to explode no matter what happened. Right? I'm not really responsible. The volcano was just a volcano. I'm not responsible. And does it matter? Does it matter if you know for certain, somehow if you know for certain the volcano is going to explode in 5 minutes versus the volcano is going to explode in 50 years? Does that really fundamentally matter? If you knew for an absolute certainty somehow the volcano will explode in 50 years and you put him on top of the volcano, it's like, well, I'm not responsible because the volcano is going to come. The volcano's natural. I'm not really responsible that I put him there. I'm like, I don't know, man. That just feels like a conceit. We know you have a warm heart as part of your charm. Thanks. That's the death penalty, not life in prison then? See, I'm not sure it is. I'm not really sure it is the death penalty in that situation. I mean, again, I feel like it's a bit of a conceit. It's like, for certain that the volcano is going to explode, but you also know for certain the Grim Reaper is going to come. Now, you're not sure exactly when. So is it different? Is it different if the volcano will explode, but you're not sure exactly when? The volcano is going to explode sometime between 10 years from now and 40 years from now, but you're not sure exactly when it's going to happen. But for certain it's going to happen sometime between 10 years from now and 40 years from now. Okay, is that different now? Because now you're uncertain when it's going to happen? Just as you're uncertain as to when the guy's going to have a heart attack? Is that different? I don't know, man. I'm not sure it is. The fact that, die from old age or whatever, I'm not sure that it is different. Either way, you're leaving him to an uncertain natural process. Is there really a difference in that? I'm not so sure. So I'm not sure that keeping him on top of the volcano example really is the death penalty versus life imprisonment. I'm not sure about that one. Is it different? I don't know, man. I'm not sure. I feel like we're having a trolley problem discussion at this point. To some degree. Yeah, it feels a lot like the trolley problem. And it feels like the abstraction is the problem. And so for those of you who somehow don't know, the trolley problem is a classic, right? You are an operator that works on a trolley line. And you are at a switch station for the trolley. And you see a trolley coming towards you that is out of control. Its brakes are no longer working, and it's completely out of control. And it is currently set to go down a path in which 5 workers are working. And there's no time to warn the workers So take that out of your mind, right? There's no time to warn the workers. But you're on the switch. You're on the switch. So you could turn a wheel. You could turn a wheel and it would switch the tracks. The problem is that the other track has exactly one worker on it. So what do? Right? Do you turn the wheel of the switch? Because right now the trolley is going to kill 5 people. If you do nothing, the trolley will kill 5 people. If you turn the thing, it will kill 1 person. So what do? Most people say I would turn it. Most people would say I would switch tracks. That is the dominant answer. And it's like, okay, let's try a different hypothetical. Let's suppose that you're, now standing on a bridge. And next to you is a very, very fat man, incredibly fat. And now the trolley is heading towards the 5 people, but there's no switch, right? There's just one track. There is no switch. It's heading towards the 5 people. Now, somehow, because it's magical hypoland, you know for an absolute certainty that pushing this guy off the bridge and him falling onto the tracks would stop the trolley. He's really fat. It would grease the skids. It would cause, it would stop the trail. You know that for an absolute certainty. Okay, so do you push the guy? Most people say no. Most people say no. And it's like, well, what's the difference? What's the difference, right? In the first example, you said, presumably, it's better 1 people die than 5 people die. And now I've given you the exact same scenario, but now you're actually more involved, right? In the scenario where you pulled the wheel, you were a little bit more detached, maybe. Because it's not that I am pushing the guy to his death. I'm merely turning the wheel. And the guy is dying as a consequence of that. So it allows you to be more mentally removed from the situation. Whereas if you push the fat guy, well, you've just directly pushed the fat guy, and now you are a direct cause of his death as opposed to it being like 1 step removed. And most people balk at that. But I'm not sure there's a difference. Right? So for me, I don't think there's a difference. So I think perhaps the answer should be the same. And that's sort of my argument when I'm just making now. It's like, okay, the death penalty is me pushing the fat guy off the bridge. Life imprisonment is me turning the switch. It will inevitably lead to his death, but I'm detached from it. And many people find moral comfort in that, and I'm not so sure that there is moral comfort to be found. So maybe I've just redescribed the trolley problem. Maybe that's fundamentally what I've done here. It's like, I don't really think there's a difference between the death penalty and life imprisonment because death is inevitable. In the one case, you're pulling the trigger or having someone pull the trigger for you, which is the same morally to me, right? It's no different like if you're a worker on the line and there's another guy on the switch and you're like telling him what to do because you're the supervisor. I don't think it really changes the hypo. It's like you're still the one making the decision, even if it's someone else who pulls the wheel. And same thing if you're on the bridge, right? If there's someone else who can push them, and you're the one that's commanding it to happen, right? It's no solution to say, well, I wasn't the one who pushed it. It's like you're the one who causes it, right? That's murder, like generally speaking, true. It's like, yeah, if I order someone else to commit a murder, I'm guilty of the murder. So it's like, yeah, it feels like a bit of a conceit to me to say that the Grim Reaper is doing it for me and somehow that doesn't really count. It feels like, it feels like an argument of I'm merely turning the switch at the switch yard and somehow I'm not responsible because all I did was turn a switch. I'm not really responsible. It feels like a bit of a dodge to my mind. So, yeah. So I think that's what I think. I think it's a bit more. I don't think the moral argument is as good as some people say it is because it feels just too much like a conceit. You can't make a moral argument without a solution? Sure I can. Why not? If your remedy is rehabilitation your way up, why not? Sometimes you may have no solutions. In some situations, it's like the no-win scenario. Sometimes that happens. Sometimes there are no moral solutions. Sometimes it's just a bunch of immoral solutions. But yeah, I don't think I necessarily have to propose a solution to say there's a moral problem here or your moral conceit is not valid. I don't think me saying you have tricked yourself. I don't think my saying you have tricked yourself into believing that you're not responsible. You are responsible. You've deceived yourself into thinking you're not responsible. So it's like you're performing a morally questionable act. And so if you come back at me and like, okay, what's the solution? I'm like, I don't know. Was I required to provide a solution? I don't know. Maybe there is no good solution. Maybe both solutions are equally immoral. Maybe there's no moral solution here. Maybe life imprisonment is equally immoral to the death penalty, which maybe it is. And therefore the death penalty no longer seems wrong by comparison, at least. Maybe they're both equally immoral. Or maybe they're both equally moral. How about that? Maybe they're both equally moral. Because you could draw that conclusion too, right? I just want a consistency in the moral logic, right? So if you say, well, I'd turn the wheel and I'd push the guy over the bridge, then you're morally consistent. If you say, I wouldn't turn the wheel and I wouldn't push the guy over the bridge, you're morally consistent. So it's just like, maybe you think both are moral. Maybe that's the solution. Maybe both are moral and neither one's immoral. I just don't think that the moral distinction is as great as many people would have you believe. I don't think the moral distinction between the death penalty and life imprisonment is as wide as has been suggested by some people. I think it is much more morally close than a lot of people suggest. So that's sort of what I was trying to say. Is law and morality interchangeable? Well, not necessarily, but we're working in a hypothetical world. So we are presupposing, like, in the discussion, we're presupposing like what the law should be, I suppose. So morals can inform our legal judgment. The law is separate from morals once we establish it, because the law is the law once we establish it, but morals can, in the first instance, inform what we think the law is or should be is more in the point. So, like, if your argument is, well, we shouldn't have the death penalty, then you're proposing a legal solution. And if your argument is the reason we shouldn't have the death penalty is because of moral objections, you're making a moral argument for a legal change. So the moral case becomes relevant towards the legal principle we want to have. So there's certainly a distinction between law and morality, but as we're considering what kind of society we want, as we're establishing the rule book, morality becomes more relevant in the creation of the rule book. Morality can be subjective, that's true, but in this solution, we're trying to figure out, well, first of all, we can figure it out for ourselves. So there's that. So first of all, we can figure out for ourselves what makes moral sense, which is a good thing to do. What do you think? What do you believe? So first of all, you can decide it unto yourself. Second of all, in a representative democracy, the collective morality is what informs law. That is a large part of how the law came to be, in a large part. The law, to my mind, and I genuinely believe this, the law, to my mind, and the common law is basically a 1,000-year-long expression of moral judgments. Because the law has, over 1,000 years, basically seen every kind of combination of victim, victimizer, and morality that can possibly occur, right? Especially sort of when you boil it down, you know, and take away like technology elements, especially, right? It's like every privation of evil and morality has been contemplated by law. And so the law, generally speaking, to my mind, is one massive moral judgment. Is the moral judgment informed by the wisdom of history? Is the moral judgment informed by the long, hard knocks of experience? And I think that every law at root is a moral judgment. It's a collective moral judgment. It's one that's been tempered by history and time, but the law is, I've said this before, the law is the distillation of the human experience. The law is the human experience written into a set of rules to be universal. So, I find that to be a very romantic notion, incidentally. I don't know whether or not you do, but I find it to be a very romantic notion. It's one of the reasons I like law, is because to my mind, law is essentially applied philosophy. That's what it is. Law is applied philosophy. It's like, what kind of system of law, what kind of system of justice do you want? What is justice? Right? What is justice? Well, law is an expression of that answer. So law is an applied philosophy. It's a philosophy that actually manifests itself in the real world, in individual cases, through a collective time-tempered judgment. So I find it to be a very romantic notion and very cool. Is it bad that your personal morals won't come into play if you serve on a death penalty jury? No, not necessarily. I think that might be valid. I don't know. I don't think so. I love the law, but it needs to go hand in hand with social justice and advocacy, and it's slow to reform. I agree it's slow to reform, and that's somewhat by design. The law is very small c conservative, and somewhat by design, because the law attempts to ameliorate out the emotion of a particular case and to try to come up with a very sort of neutral rule. It's been said before that justice is and should be cold-blooded, and I tend to agree. You want the rule, right? The rule should supersede because you believe in the rule, or at least I do, right? I believe in the rule. Now, I might want to change the rule, and that's fine, but if I change the rule, I have to do it in a universal way. And that's the challenge, right? To change the rule in a way that I can apply it universally, because I sort of believe in categorical imperativism. I believe in the categorical imperative, like Kant said, Immanuel Kant. I like him very much as a philosopher. So I believe in the categorical imperative. We need to create a category, and we must do it imperatively. So I have no objection necessarily to changing the rule. But when we do change the rule, it should be thought out with caution and humility, because we're changing the rule in a universal way. One of the reasons that the law is good is because it somewhat tempers our feelings in the moment to help produce a more just result, as opposed to it being more of a mob-based exercise, because that would be the alternative, right? The passions are so inflamed that we allow or even a mob for good. So a mob can be for evil and a mob can be for good. You know, the passions are so inflamed that we must, punish this person, or the passions are so inflamed that justice must be done for this person because they've been so harmed in some way. So the law is meant to somewhat control our emotion and work for a logic. I think it's a moral logic, but that's what the law does. It is meant to try to find the rule and apply the rule in a universally consistent way, to my mind. That's how I think. I think in rules. I think in procedures. That's how I think. I think I want to find a rule and try to just follow the rule on the idea that following the rule will inevitably get me the right answer. That's the reason the rule exists. So it will give me the right answer. And if it doesn't give me the right answer, then I need to rethink the rule. But here's the critical part. I need to rethink the rule in a universal way for all of time, because I don't want to be arbitrary about this. I don't want to adjust this one time, because that's a recipe for arbitrariness, you know? Sometimes that's unavoidable, but I really would like to avoid it to the maximum extent possible. I really don't want to make the just this one time, just because it's this important, this one time argument, because common law doesn't tend to work that way. It tends to not be just this one time. That's not really how it works. And even if it could work that way, it's arbitrary. So I'd prefer to come up with a universal rule set. And that's one of the reasons I try to think about these issues in a really deep way, so that I can try to find a universal rule set so that my personal feelings will not change the judgment. You know, facts don't care about your feelings and so forth. Yeah, they will never be your pinky promise, says the crumbly prosecutor. Yeah, this will never be you. Yeah, that's a lie. Yeah. The crumbly prosecution is a pretty good example of exactly what we're talking about. Should parents be held responsible for the crimes of their children? Maybe, but, you know, it'd be helpful if you did it in something resembling a universal fashion. I'm confused. There's something on Zoom. We are
on the record now, KCR,
but not the court's document. I'm on the court's webpage, but it's not displaying right now. So give me a second. I'm going to change feeds, because I was on the court's docket like, you know, a smart person, and it has betrayed me.
Small groups. The defendant is here present, represented by his attorney, Mr. Pryor, the state and prosecutor.
So give me just a second, please, to change the feed. This has been a fun philosophy discussion. I've enjoyed our discussion very much. Hopefully, I've given you something to think about at a bare minimum. If I've given you something to think about, I feel like I've done my job. These are tough questions, incidentally. They're not easy. Especially when you're talking about life and death. I mean, you know, that's pretty hard. So they're not easy questions, but it's helpful to think about them, and helpful to try to think about them in some way that ideally produces a consistent result would be nice. Yeah, it was a good discussion. It was a good discussion. All right.
To the defense, prior to the groups coming in, the 16 groups of
you shall credit Kurt in this amazing chat and citations.
Just
excellent
confirmation of my understanding on that.
I look forward to reading whatever you write.
One of the prosecutors, Mr. Wood.
That is accurate, Your Honor. And just for the record, be fully accurate. The state is allowed to share that information and allow Mr. Pryor to review those. We are not allowed to.
Has an innocent person be executed by mistake? Of course.
To anyone outside of our office.
Of course, but also people have died in prison from a life without the possibility of parole by mistake.
Yes, Your Honor. Thank you.
So I'm not sure.
Okay. Thanks, counsel.
I'm not sure necessarily mistake necessarily does it either.
The one other issue I
because
bring up briefly.
There's a bit of a conceit that life without the possibility of parole gives us time to fix the error. But of course, it would be ridiculous to argue that every single time we fix the error. That's insane. Sometimes we fix the error, but then again, sometimes we fix the error in the death penalty now, don't we? Sometimes we find out we were wrong and we don't give the death penalty. So I'm not sure how often we realize we effed up.
No, Your Honor, the state
Either
did read
way.
over that comment. I think
But
that
I'm
that
not sure
would be
we
in
executed someone
violation
by
of the court's order.
mistake,
It sounds like she
or
tried to
more the point that they were in fact not
violate
guilty.
what
We
this
executed
court
an innocent
ordered.
person
Okay, thank you.
versus
Any concern
we
from the
allowed the
defense as
person
Juror
to die
791?
in prison
Judge,
without,
I
you know,
don't
life
know
without the
the
possibility of
level
parole
of
as they slowly looked at the
discussion
wall
that's referenced.
until the Grim Reaper finally visited them,
I think
and
I
that was
shared
by
what was
mistake.
in the
I'm not
email.
sure how much the fact that we execute someone versus mistake versus life in prison without mistake and they died. I'm not sure how much is in that either.
It's unclear. There obviously
So,
was an acknowledgement,
Yeah,
and there was
that's
some
the
discussion. I'd like to know the level of that discussion. What I am concerned about is whether there's been a change in the form of.
I mean, no
or
one wants
not.
to execute someone by mistake, but presumably no one wants to send someone to life
Issues
without the
discussed,
possibility of
feelings
parole
of coworkers discussed.
by mistake either.
That's where
And it's one
sort of
hell of a
engagement
conceit.
took place.
And I think a bit of a false conceit. Oh, you know, if we give them life without the possibility of parole, it gives us time to fix the error, don't you know? So we'll fix the error. But I would imagine, I wouldn't know for sure, but I would imagine the vast majority of life without possibility parole errors are not
There was a
correct.
discussion, they said they kept the discussion to a
So,
minimum, so I think that is an appropriate line of inquiry on board there. If you have further questions about that discussion and this juror's following of the affirmation, I'll permit that. Likewise, the state's permitted to inquire on that issue also. The jurors now that we've confirmed are not going to be appearing as part of this group would be jurors number 823 and jurors number 1112. So the remaining 14 jurors from this group are here. We will proceed then with bringing those jurors in to continue with our four-hour examination of them. Is there anything else the state needs to address before the jurors are brought in?
And Your Honor, just to be clear.
Yeah, I
missed
definitely
it.
can't
Is
do
the
games
court
and
going to
do
excuse
research
those
at the
jurors, or are
same
we bringing
time.
them in
That's
later?
too much.
Well, we've got the one group today, so at least the one juror.
You
that's on
guys
their
are
way
thinking
is
I
gonna
should
be
do
instructed
RimWorld
to return.
on screen while you're
likely
listening to jury
tomorrow morning.
selection? Is that what we're
The
proposing?
other juror we haven't heard from, so I'm not sure.
I mean, we
Thank
could
you.
do that,
just
I
wanted
guess,
to
at least for the morning
make sure that we
session.
kept them in the pool if they may still be coming back.
Okay, I'll confirm who's who. and
Are
what
we doing
happened and whether we
RimWorld
get any
and
word from the other
jury
missing
selection, at least in the
juror.
morning?
And when we conclude this group today, I'll let council know if and when these particular jurors are going to return for further court hour.
I mean, it's not like there's much to see, so there is that.
Beyond that, anything else from the state before the jury's brought in?
Nothing further. Thank you, Your Honor.
Something to think about.
Okay. Ms. Bailiff, if you'd please have the jurors brought in.
RimWorld is a video game. It's a computer base builder game. You build a base and defend it against attackers and launch attacks yourself and eventually try to, you know, escape from the planet and stuff. It's fun. Challenging. There's a new expansion, or there's a new version of it coming out pretty soon. In the next couple, I think it's 2 weeks away at this point. The person who runs it announced it. They're coming out with a new version and a new expansion, which is pretty exciting. Like Minecraft, I haven't played Minecraft to know, but it's a 2D game, a top-down 2D game. So it's different in that way. Yeah, it's more passive. Yeah, you're not actually doing things. You're more commanding the pawns to do things. Yeah. So it's much more passive. You can command them a little bit, but for the most part, they just follow the commands that you've set out for them. Yeah, more like SimCity. Yeah, that's a good point. Assassin's Creed Valhalla. I played Assassin's Creed Valhalla a little bit on stream before. We never finished it, but we did play some on stream. We could theoretically go back to it. I played it for a while and then I just kind of didn't find it as fun as I expected. but it was good for a while. Did I finish Zelda Tears of the Kingdom? I did not. You got bored with it? I understand. Warcraft 2 was awesome. I liked Warcraft 2. I played that online, and I liked Warcraft 2. I miss Warcraft 2. It's a great game. Warcraft 2 kicked ass.
All right, thank you. Here you are. Thank you. Please be seated.
I think I should do legal research this morning while I'm still sharp. And this afternoon, if I burn out on legal research, which seems very possible, maybe we'll do RimWorld this afternoon. So I think that makes more sense. So I'll do legal research this morning, and maybe we'll do RimWorld later.
Versus Chad Guy Daybell. I'll note that the defendant is here present, represented by his attorney, the state's president as well, represented by the prosecution. Before we begin the jury selection process here this morning, I'll first inquire, beginning with the state, is there any objection to the manner in which the jury panel has been recalled and seated today?
No, Your Honor, thank you.
If found guilty, is there a second trial? There's a penalty phase, but it's not a second trial, really. The same jury would be asked to decide on the death penalty.
16 jurors summoned to appear today.
Doom was pretty good. The Doom remake was also pretty good, incidentally.
Has failed to appear.
It was fun.
Juror number 823, for some reason, was running substantially late and is going to.
How's work going on Supreme Court case? It's going great. In fact, I'm about to do some right now.
Likely tomorrow. The remaining jurors have all arrived and reported, and thank you for coming today. Let's next have a roll call by the clerk, if we could, to confirm who's here. And when your name's called, you can please raise your red number so that we can confirm where you're seated.
Let's see, where was I?
I'd ask you to please answer audibly when I call your juror number. Juror 752.
Okay, I did that one.
Yes. Juror 791.
Yes.
Juror 792.
Did I read this one too? Mist?
Juror 899.
I never liked Mist.
Juror
I never liked
909.
Mist.
Yes.
Juror
I
922.
find the puzzles incredibly confusing,
Juror
not at all
923.
intuitive.
Juror
I
924.
didn't like Mist. I found Mist
Juror
annoying.
937.
I know a lot of people really
Juror-
love Mist, and I don't
Juror
begrudge it,
951.
but it just was not my thing.
Juror 1004.
Here.
Juror 1032. Juror 1048.
Yes.
Juror 1057. Yes. Thank you.
All right, thank you, Madam Clerk. Ladies and gentlemen, thank you for returning this morning. You've been recalled here as prospective jurors in the case now before us. I'll reintroduce my court staff and myself again. I'm Stephen W. Boyce, the District Judge of Fremont County, Idaho. I'm in charge of this trial in the courtroom here today. Our court clerk assisting this morning is Shannon Holstein, and as she's keeping minutes of these proceedings and will administer oaths to you as jurors. The marshals are here also assisting, maintaining courtroom order. Deputies Holmes, Page, and Vallow are here, as well as the court reporter, Mary Fox, who's taking a stenographic record of everything said during the trial proceedings. Also, my staff attorneys, Courtney Stallings, seated to the right, and she assists me.
Thank you for saying I make an excellent judge. I think so too.
During the case. You are all qualified to serve as jurors of this court, and each of you filled out a questionnaire that's now been reviewed by the court and the attorneys, and it was determined you would be recalled here for further questioning today. What we're doing in the trial at this stage is to select 18 jurors, which will be 12 jurors with 6 alternates from among you. At this time then, to assist you in understanding and participating in the jury selection process, I'll reintroduce you to the parties and their lawyers and summarize what the case is about. Before I do that, I will note with that juror that failed to appear, the court will issue an
Yeah,
order
Mist
to
was
show
very annoying and
cause and determine
non-intuitive.
whether or not that juror should be subject to a fine and/or jail for failing to
I
appear
agree.
pursuant to provisions
It was a
of Idaho
technological
Code,
marvel
Title
for sure,
7 and Title 2.
but
At this time then, to introduce the parties, beginning with the state, I'll sometimes refer to the state as the prosecution. If each of you would stand as I mention your name. In this case, the state is represented by Lindsay Blake, who's the Fremont County, Idaho prosecutor, Rob Wood, Madison County, Idaho prosecutor. Ingrid Beatty is a specially appointed prosecutor, and Rocky Whitson, a deputy prosecutor also. The defendant in this case, Chad Guy Daybell, is represented by his attorney, John Pryor. This case is a criminal matter, meaning the defendant is charged by the state of Idaho with violations of the law. I previously read to you, when you filled out your questionnaire, the amended indictment. And with regard to the defendant, then the state of Idaho has alleged that Chad Guy Daybell committed the following crimes, as alleged in that amended indictment. Count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. Count 6, first-degree murder. Count 7, insurance fraud. Count 9, insurance fraud. Mr. Daybell has pled not guilty to the charges. Please remember, that is simply a description of charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means 2 things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence, you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. I'll next discuss your duty as jurors. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying those instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is, what the law should be, or what any lawyer may state the law to be. During the course of this trial, including this jury selection process, you're instructed that you are not to discuss the case among yourselves or with anyone else, including any use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time then, I'm going to ask our clerk to administer an oath to the entire jury panel for this voir examination. Ladies and gentlemen of the jury, if you would please rise at this time and raise your right hands.
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by the court or counsel, such upon your qualifications to sit as a trial juror in the cause now on trial, so help you God?
Thank you. Please be seated. I'll note on the record, the court observed that all the jury panel was placed under oath for this proceeding.
I feel good.
At this time, I'm going to
No,
ask
I would not.
another question regarding this impaneling. Will the attorneys stipulate, beginning with the state, that the jurors now have been properly called and impaneled? Does the state so stipulate?
Yes, Your Honor, thank you.
Thank you. Will the defense agree?
Yes, Your Honor. Thank you.
Thank you, Mr. Pryor. The jurors have also completed their juror affirmations this morning, and the court appreciates you following the court's admonishing instructions. At this time, I'll discuss now the nature and purpose of this voir dire. This is the part of the jury selection process where you will be asked questions touching on your qualifications to serve
How old
as
am I? I am
jurors in this
43.
particular case.
And feel
This part of the
great.
case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of the common law. In Old French, it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand this questioning is not for the purpose of prying into your personal affairs, but only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your red card so we know who on the record is speaking. And when you're called upon to speak, because we are making a record, please communicate verbally your responses, such as answering yes or no instead of nodding your head or shaking your head, and try to avoid speaking at the same time as any attorney questioning you or the court so that the record is clear for our court reporter. If you have an answer to any question that you feel is too personal and embarrassing to you to answer publicly, please let me know and we can discuss that in a more private setting. I will acknowledge here that we are live streaming this proceeding. However, jurors are not part of that broadcast. However, your verbal responses are being broadcast on that. You're just not being shown on any video. Similarly, if you think you have an answer to a question that may prejudice other jurors for information you may know about the case, please refrain from saying anything about the facts of the case, and we'll discuss that outside of the presence of your fellow jurors as well. At some point, we will discuss with each of you individually as needed your exposure to any pretrial publicity in this case or facts of the case. I will now read you a special instruction in this case, which is as follows. The defendant, Chad Guy Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Vallow Daybell and or Alex Cox. The crime of conspiracy involves an agreement by two or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. That concludes your special instruction. At this time, I'll also ask that the attorneys be mindful to not repeat questions already asked by the court or other counsel. The attorneys do have the right, however, to direct any follow-up questions to a juror regarding that juror's response to previous questions. The jury should be aware that during and following the voir dire examination, one or more of you may be challenged. Each side has challenges for cause, which means that each side can ask a juror that a juror be excused for some specific reason. In addition, each side has peremptory challenges, meaning they will be able to exercise challenges without giving a reason for the dismissal. If you're excused by either side, please don't feel offended or feel that your honesty or integrity has been questioned. It has not. I'll now begin the court's portion of the voir dire process, after which the attorneys for both parties will be given an opportunity to make their own inquiries. When I'm addressing questions with the jurors, please pay attention to those questions because you may be called to ask or answer those same questions later. The first General question I'll ask to all of you as a group is regarding your questionnaire. Are the answers given by each of you in the juror information and in your juror questionnaire you filled out last week still true and accurate? If those answers are still true and accurate, please raise your red card at this time. All right, every juror indicated their answers are still true and accurate. The next issue the court wants to discuss is the time commitment required for this case. If you're required to serve as a juror in this case, it will be for a period of approximately 8 to 10 weeks. Would that period of time create a serious hardship upon you or your family or your business or profession or occupation so as to prevent you from rendering service as a fair and impartial juror in this case? If you believe that it would be a hardship for you to serve, please raise your red card at this time. Okay, we have a number of those. If you please hold those up for a moment, I'm going to list those out, let council do the same. All right, thank you. We'll take up these hardship concerns first with the group. We'll start with juror number 792. So give me a moment, I'll look at the questionnaire. And during this phase, I may have the council inquire as well on specific hardship questions during the course portion of the voir dire here. So juror number 792. You've got a couple of personal issues you brought up there, in addition, employment concerns. Can you explain what you think would occur if you were required to sit as a juror in this case for that length of time?
I was out of work for about 10 months, started a new job about 5 weeks ago, so just getting my footing.
Is that new job a full-time employment?
Yes,
Have you discussed with your employer the possibility that you would be required to serve on this jury?
yes.
And what did they indicate would be the status of your job if you were gone that long?
Maintain the job, no pay.
Okay, so you wouldn't lose your job, but you would not be paid for the term you were gone?
That's my understanding.
Any follow-up voir dire from the state?
No, Your Honor, the state also had a note on the hardship to follow up. I think given that additional information that he would receive no pay during his service here, the state would make a motion to remove him for cause based on hardship.
The defense is going to stipulate to releasing him for cause, judge, in this situation.
Okay, well, given your employment situation with that new job, just coming off a term of unemployment, the court finds that would likely create a serious financial hardship for you, given the length of this trial. So for that reason, juror 792, I will sustain the for cause challenge based on a hardship. So thank you for coming in and filling out your questionnaire. I'll allow you to be excused. You can please return that questionnaire to the bailiff on your way out. So next, talk to juror 899. Did you raise your card, please? Did you raise your card about a hardship also?
I did.
Okay, thank you. I note in your questionnaire, you didn't mention something on that. Can you explain to the court what the hardship would be?
Yes, my husband's job is ending in May, which means that I will be making up more than 50% of our income, and I'm afraid of losing our home, not being able to pay our mortgage until my husband can find a new job.
When in May would that be occurring? Do you know?
he said that towards the end of May. I'm not entirely sure.
If that did happen and you were here doing jury duty still through that time period, do you believe that would become a significant distraction for you to be concerned about your financial situation?
Absolutely.
All right, and again, counsel, this one didn't have an indication here in the questionnaire, but that's why we bring jurors back. So I'd like to have a little more dire from the state and the defense to make a determination, beginning with the state.
Your Honor, the state did not have the note of hardship. We did intend to talk about some other things, but given that information today, I think the state would simply make a motion to excuse this juror for cause based on hardship.
All right, Mr. Pryor, response for the defense.
Judge, I'm inclined to agree with the statement. The court would like me to elaborate a little bit on the level of that hardship. I would, but I think given the circumstances, I'd stipulate. I'll defer to the court. If the court wants before I elaborate some more, that would be fine. But given the statement, I feel that the distraction of worrying about having a home to live in is significant enough for release.
Okay, juror 899, I guess I'll just follow up briefly. You indicated you thought this might put your housing situation in peril if your husband's job ended and you were not available to help support family financially. Is that correct?
Yes.
Okay, based on that concern, I do think that would pose a significant distraction for you during the course of the trial and the potential financial hardship. So the court is going to accept your representations on that issue and allow juror 899 to be excused based on a motion to strike from the state without objection from the defense. So thank you for coming in last week, filling out your questionnaire and returning today. You can be excused with the thanks of the court. Please drop your questionnaire off to the bailiff.
I'm just looking for a new feed. Give me a
Let's
second.
talk to juror number 923.
Thanks.
Let's talk to juror number 923. All right, juror number 923, you've expressed a concern in your questionnaire about both being a student and working. Could you elaborate on why this would create a hardship for you?
Yes. My classes probably go into mid-May, and I'm see those. We're not able to focus on those. And then I do work full-time as well, and balancing the shifts could be kind of hard. And then if I wasn't to work, I'm working in probably use national apartment.
Have you discussed your potential service with your employer?
Yes, we didn't mention pays for the time. I can ask about that. They didn't say anything about it, so I don't think that I would be paid, or they wouldn't.
All right, does the state wish to follow up before Dyer?
Your Honor, the state actually already had a note here as well on hardship. We had noted that she indicated she was a full-time student and that she worked full-time. I think given that additional information, just going off what we know today, it sounds like she would not be compensated for her missed work time. I think all three of those things together would create a hardship. So the state would make a motion to excuse juror 923 for cause based on hardship.
All right, Mr. Pryor, as to juror 923.
Judge, I was also going to request that the court excuse 923 hardship as well.
All right, juror 923, then the court will sustain the strike raised by the state and agreed to by the defense, allowing you to be excused for hardship. Thank you for completing your questionnaire and returning today. Please drop your questionnaire off with the bailiff on your way out. Next, talk to juror number 924. In your questionnaire, you stated, I have work out of town. You didn't have any other detail. Could you describe what type of work that is, when that would be out of town, and how it would impact you if you were during trial?
Yeah, I'm a musician, so I travel to other towns to play music. The work isn't always set. It kind of comes in as I go. So like in a month from now, I don't exactly know where I'll be, but generally the work is Thursday, Friday, Saturday, Sunday. So that just makes it impossible for me to leave town.
And is that your sole source of income?
Yeah, my wife and I are together and we kind of share our incomes. So it is my sole source, though, yes.
Inquiry from the state?
Your Honor, we also have, had noticed that hardship of having to work out of town and had planned on following up. But given the additional information today, the state does believe that this would pose a hardship for juror 924 and would make a motion that he be excused for cause based on that.
All right, from the defense, Mr. Pryor.
Judge, I also had a note to excuse this juror for hardship based on the fact that he has to make a living traveling outside of town, and I think that's a significant hardship to have to try to make a living, perform jury service while he's also trying to travel out of town to attempt to make a living. So I'm excuse.
All right, court's considered the challenge there, given that that is your sole occupation and source of income. The court will sustain the challenge 924 as excused for hardship. So thank you for completing your questionnaire and returning. You can drop that off with the bailiff on your way. All right, juror number 937. Thank you. You put quite a bit of detail in here in terms of what was going on with scheduled medical appointments, et cetera. I reviewed that. It is a concern about a hardship. Are these appointments that could possibly be rescheduled, or would that be too difficult?
No, they could not be. Most of these appointments were scheduled months ago. One of the ones I get are Botox shots for migraines, and if I don't schedule that the day I get them, I wouldn't get another one in 3 months. So it's when my next shot's due in May, and schedule for that. So
Okay, and those are specifically for management of migraine headache pain?
Yeah. And I still get that, so it makes them less frequent, less severe. So some of it's medical appointments. I'm a single mom widow, and I have to take my minor daughter to a couple of doctor's appointments as well. So I'm the only parent that can attend those appointments like that. I usually work little bits of time, often out of state because of a long story anyways. But I am getting short on money, and I may very well need to take another short-term job before we're planning on moving to Oregon, because I may run out of money and not be able to pay the bills. So I can't do that if I'm working to trial for 8 to 10 weeks.
All right, I appreciate your explanation from the state and follow-up board.
Thank you, Your Honor. We also had marked down to talk further with Juror 937 about the listed hardships. I think the court already went over the questions with regard to rescheduling and that kind of information. Given everything from Juror 937, the state would make a motion to remove her for cause for hardship.
All right, from the defense.
Judge, I concur in that motion. I had her marked as being excused for hardship.
All right, Juror 937, thank you for your service in completing the questionnaire. I'll sustain the motion of the state without objection of the defense that you stated a sufficient rationale for a hardship preventing your service in this case, given the length of the trial. So Juror 937 may be excused. Please drop your questionnaire off with the bailiff on your way. Next, talk to Juror 1004.
Wasn't this brought up yesterday? Yes, it was, with a different panel of jurors. We're starting again with a new panel of jurors. We did this twice yesterday, and now we're doing it for a third time, so we're here again.
All right, raise your card, please.
Yes, Your Honor.
Thank you. In this case, you didn't indicate anything in the questionnaire. Would you please explain what's going on?
Today is probably going to
hardship
sound a
at this
lot like
point?
yesterday.
Yes, Your Honor. As far as employment goes, I'd be able to retain that. And I'd be basically be FMLA and a protected pay. So it'd be coming out of my pay account or my time I've built up. It would require additional staffing to be called in to fill my position due to the nature of my job. The additional issue would be with child care.
Enthused?
And the cost of
Yeah,
child
Ms.
care.
Enthused is a situation
My
well
wife's
for.
current job that she'd be getting soon would be essentially a 9 to 5 every week for the foreseeable future. And if I was required to attend here, I'd have to provide childcare for my 3-year-old, and then also for my 12-year-old, and my 15-year-old is currently employed, and I help with his mom to take him to and from his current employment as well. So being unavailable to be there for that.
Were all the potential jurors excused? No, I think 16 made it through yesterday.
To even find childcare for them, and also I'm sure
That's the number I've seen reported at least.
With me not being able to take them on the days that's currently scheduled for me to have them.
All right, you're currently a police officer, is that correct?
Yes, Your Honor.
And are you saying that your department won't, or your employer won't cover jury service?
So I believe they will. I'm not clear. I've discussed with them the potential of needing to be here. I'm a little unclear, and that's entirely on me as far as exactly how that pay would go. I certainly would be compensated and certainly wouldn't lose my employment. But due to minimum staffing requirements for our department, if I wasn't available, there would be frequently days where other members would have to be called in on their days off to fulfill my position.
Okay, thank you for the explanations from the state and Gordar.
Your Honor, I just would like to clarify. I think I understood correctly. The concern sounds like when your wife's at work, you provide the child care.
So I will clarify. So my current wife is the one that's beginning a new job. Her and I have my 3-year-old daughter together. My ex-wife is the one I have my 15-year-old and 12-year-old with. We have a custody schedule. And I would get them for, part of the week, and she gets them for the other part of the week. So if I was unavailable, per the agreement, she would be the first one I'd have to ask to cover for that. If she was unavailable, then it would be a child care issue, trying to find care for them. Not so much for my 15-year-old, but getting him to and from his place of employment so he didn't lose his job that he just began as well. So it'd be a custody potential issue if she wanted to make it, which wouldn't be surprised if she did. But then for my current wife, it would be just the cost of finding constant daily long-term care for my 3-year-old.
Because when your current wife starts her new job, you would be providing the child care for the 3-year-old at times, at least?
Yes, ma'am.
Okay, I just wanted to make sure I understood that. And you do not have childcare already set up or anyone in place.
So
correct?
we do have someone in place. I'm not sure if she's going to be able to fulfill every single day of the week during the normal work week. Right due to the way our schedules work, she watches my daughter. There's only a couple days a week that we need coverage just because we've adjusted our schedules to where we actually work opposite sides of the week. And there's only a day or two here and there where we actually need coverage. Other than that, we just switch off with those duties.
Thank you for that additional explanation. I just wanted to make sure I understood correctly. Judge, given all of that, I think it does rise to the level of a hardship, and the state would make a motion to exclude Juror 1004.
Mr. Pryor.
Judge, I'd also agree that 204 needs to be excused. As a lawyer, I'm well aware of the difficulties when ex-wives need trying to navigate through custody and the impact actually on your two teenage children. That has to be taken into consideration, along with the fact that the financial burden of having to provide additional child care for your children. I think it's necessary that you be excused. I don't know that we should force him that burden.
All right, I'm considering this one. Juror 1004, in your questionnaire, you indicated that your current wife is also a police officer. Is that correct?
That's correct, sir.
All right. Having considered the challenge here, the court is going to deny the challenge to strike. I don't find that there's a for-cause hardship represented by this prospective juror rising to the level that they would be unable to serve in this case. While I understand that may be hugely inconvenient if the trial really goes as long as we've scheduled, it's an inconvenience for anyone required to sit for that length of time. And based on that, juror number 1004 will remain in for further individual questioning or group questioning. All right, the next hardship issue raised was by juror number 1032. All right, thank you. All right, this juror's requested a hardship excuse in the questionnaire, talking about employee training and employment issues, and also issues with tending to children, including a special ed child. So would you please describe to the court in a little more detail about how this may impact your employment as well as your family issues involving your children?
Yes, so as far as the employment, I verified that I will get paid for at least 6 weeks. We're still going down with the chain to make sure that it would go to 8 to 10 weeks. So I'm pretty confident that I would get paid. The inconvenience and hardship would be more family related. My wife and I are the sole providers here. We have no family, no caretakers. I'm the one that makes breakfast, gets her girls ready. She has to leave the house by 6:45. She's a special ed teacher. To clarify, our kids are not special ed. She's a special ed teacher. For example, the past week when I had to come for jury duty, and today she has to show up to work 3 hours late. It's kind of a ripple effect on her. Our schedules, the pickup schedules to the 6 and 3 year-old that we have. To add icing to that cake recently, we just had a family diagnosis of cancer, stage 4, which is out of state, and we've been trying to monitor it. Hopefully it doesn't turn into the worst case scenario, but she may have to travel depending on the circumstances in the next 4 or 6 weeks. We hope it doesn't get that level, but there is a possibility that she may travel, and if she travels, that kind of leaves me in limbo with the kids. Kind of uncertain.
All right, thank you for that explanation. Let me go on to the state then and ask the state if they have any board dire on the hardship request.
Judge, the state does not have any questions at this time.
All right, Mr. Pryor.
Sir, all of these things, the thought of, I'm sorry about the cancer diagnosis, I really am. All of these things that you just talked about are going to be distractions for you. That'd be fair.
I think that's fair.
And these distractions, are they going to be in any way impact your ability to listen to the testimony and make a fair and impartial ruling in this case? Is this going to be something that you're going to be thinking about and not focusing on the significant importance of this case?
I think that's safe to say my mind will be wandering on other things, yes.
Judge, based on that, I'm going to move to excuse this juror for cause.
All right, based on those further responses from the state, the response to the motion to strike.
Your Honor, the state has no objection.
All right, given those previous responses, juror number 1032, the court is going to find that service in this case would constitute a hardship, disallowing their service. So I'll sustain that defense motion to strike. And you can be excused with the thanks of the court. Please return your questionnaire to the bailiff on the way out. I believe that concludes discussion of hardship with this group of jurors, and thank you all who are remaining here at this time. The next matter we'll go into.
We approach just briefly.
Yes. All right, we're back on the record. I had a brief sidebar with counsel. On the issue of hardship, we had one other juror that we just wanted to talk to about that, juror 752. Thank you. You did indicate in your questionnaire you believe you had a hardship. We didn't discuss that, and I don't see that you raised your card. It was work-related issues. Do you have anything to indicate on that, or have you resolved any potential hardship, and would you be able to serve given the timing?
So I am currently the CFO of the entity that I'm at, and I know everybody has time commitments, hardship and stuff. I do have a stay-at-home wife. I have spoken to the CEO of the company to let him know we're trying to figure out backup plans. I didn't, like say, I didn't feel we could potentially work around it, but if I get sequestered, that become issues around month end, quarter end. Those are always tough times. But I just feel like everybody has those commitments, work commitments. I didn't want to make it a bigger deal just because that I'd be different.
Okay, well, I appreciate that. With that in mind, then you do believe you, if required to serve here, would be able to do it and give this your full time and attention if that was the requirement and you were selected?
Yes, I do.
Okay, thank you for your responses on that. With that, if council has any further questions, I'll just allow that in the section of voir dire, and we'll pass over remaining for hardship questions and move on. The next matter we're going to discuss relates to your potential knowledge of the case. You have heard a summary of the charges made in the amended indictment. Other than what I have told you, do you know anything about this case, either through your own personal knowledge, by discussion with anyone else, from anything you've read or seen in the internet, newspaper, television, radio, noting this is a highly publicized case, so many jurors have heard of the case. And if you have, we will discuss that. And again, the details of that will be discussed individually with you. So don't bring up any facts. But if of these remaining jurors, if you have knowledge of this case, meaning more than just what you heard described by the court, would you please raise your red cards now? Okay, so we've got most of the jurors here, and if you'll keep those up for a minute, I'll get these all noted as well as counsel. Okay, thank you. We are going to move on. We'll note that and discuss that information with you individually as you're brought back in once we do the group questioning here. Next issue I want to bring up is as it relates to the charges in this case. I've read to you more than once now what the charges are, but this case has charges involving murder, conspiracy, and insurance fraud. Is there anything about just the nature of those charges or the subject matter of the case that would make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict? Okay, no one affirmatively answered that. I'm going to next ask some questions that might seem very obvious based on your questionnaires, but I'm required to go through these on some Idaho statutory authority to make sure there's no connection between you and any participants of this case. So next question, are any of you related by blood or marriage to the defendant, or do you know him, Mr. Daybell, from any kind of business or social relationship? All right, no one answered yes. I'll next ask about any legal relationship you may have with participants here. Does the relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger exist between any of you and any of the attorneys here today? No one affirmatively answered that. Are any of you a party in any civil action, civil lawsuit against the defendant, Mr. Daybell? No response to that. Have any of you ever brought a criminal complaint against Mr. Daybell or been accused of a crime by any of the 4 prosecuting attorneys that are here present today? No one responded to that. Do any of you have any kind of an attorney-client relationship, previous or current, with Mr. Pryor or his law firm? No one responded to that. Do any of you believe you've already formed or expressed an unqualified opinion that the defendant is guilty or not guilty of the offense charged? And if so, please raise your red card if you already have an opinion of guilt. All right, we've got one, juror 1057. And we will discuss that with you individually, 1004 and 951. And then we'll discuss that with you individually. Somewhat related here, do any of you have any bias or prejudice either for or against the defendant, Mr. Daybell? No response to that. Are any of you unwilling to follow the court's instructions to you as the jury as to the law that you must apply in determining this case? No one responded to that. Do any of you have a religious or moral position that would make it impossible for you to sit in judgment of another or to render a fair and impartial verdict? No one responded to that, and I'll note we will ask you further questions individually that may cover that topic as it relates to the state's notice of intent to seek death penalty in this case. Are any of you selected as a juror in this case unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court. All right, no one said yes to that. A final catch-all question here. Do any of you have any other reason why you could not give this case your undivided attention and render a fair and impartial verdict? No one answered that question either. At this time, then, that concludes the court's portion of voir dire. I'll now allow the state to have its voir dire followed by the defense. Who's going to be doing voir dire for this group today?
I will be, Your Honor.
All right, thank you, Ms. Blake. If you'd like to go ahead and question Ms. Juror, you may do so.
Thank you. And thank you, ladies and gentlemen, for being back here this morning. I know this one's been a bit of a longer process, and you were all here last week to fill out some questionnaires. So we appreciate you hanging in there with us while we go through this. The reason that we go through this whole process is we want to do our best to ensure that both the defendant, Chad Daybell, and the state get a fair trial. And so as we go through questions today, that's what we're looking at. That's why we're asking you questions. So as we go through this, I don't mean to put anyone on the hot spot or in the hot seat, so I hope no one feels that way, but we may ask you some questions as we go through this. If I use the term brutal honesty, what comes to mind? Juror 1048. If I use the term brutal honesty, what does that make you think of?
The first thing it made me think of was beating someone to death. I don't know. That was probably not the answer they were looking for.
Straight facts and straight truth.
Thank you. And Juror 909?
I guess it was her enunciation. Brutal. It's like, okay. My first thought was like, yeah.
You would be
First thought was
completely honest
violent.
regardless of how it might make the other person feel.
Thank you for that. And the reason I bring that up is as you sit here today and answer these questions, we're going to ask you to be brutally honest. And so it's part of the process today. And then if selected as a juror, at some point, you're going to go back with your fellow jurors when the court instruction says you can start talking about the evidence and what you've heard. And you're going to start having discussions. And we want to make sure that anyone here can be brutally honest both today through this process and also when you go back into that group setting, that you can be brutally honest with each other and speak up. So that's why we talk about that. And I don't know if any of you know, to me, when I think of brutal honesty, my niece, one of my nieces comes to mind. So she was my first niece, and as this little girl, I quickly learned if I wanted to know the truth about something, I could go to her. If I wanted to really know how my hair looked that day or how an outfit looked, she did not hold back. She let me know. And I think we probably all know somebody like that, that whether it's a little kid or the filter, and I don't know if all of you know someone like that that's kind of your go-to to get that straight answer. And Juror 1057, I think I saw you nod at one point. Do you have someone like that in your life that will just give you that straight answer? The judge talked to you about the subject matter of this case, and we didn't have anyone raise their hand that they couldn't sit on this. As you're aware, this case does deal with several counts of conspiracy to commit first-degree murder, as well as several counts of first-degree murder. There was a question on that questionnaire. Some of the images that you may see in this case may be graphic, they may be disturbing. It's normal and it's fine to be disturbed by these images, but I just want to check, is there anybody on the panel today that have seen images of, say, children, and maybe not the best images, graphic images, disturbing images? Is that going to cause anyone here concern that they couldn't be fair and impartial? Juror 1057. Let's talk a little bit about that.
It wasn't children, but my brother-in-law caught on fire and I put him out. And it's been a long time. And after filling out this and being here, more of those thoughts come to my mind.
Of what you saw that day?
Yeah. And smelled.
So in your mind, if you were,
That's intense.
and that's a fair answer, and so not trying to put you on the hot spot, but just asking a few more questions. For you, if you were to see images, would you be able to set aside any thoughts of your brother-in-law and be able to just look at the images and give them the weight you think they're due in relation to any other evidence presented?
I think I could.
do you think it would be so upsetting that it would cause you any kind of physical or mental anguish to the point that you couldn't be fair and impartial?
I don't know if I can honestly answer that, but I do know that I've been having trouble sleeping.
And when you say trouble sleeping, did that start, do you mean since you've been selected to potentially be a juror?
Yes.
And do you feel that's impacting your life in such a way that it would affect your ability to sit as a juror in this case?
I would hope not.
Thank you for your honesty. When I talk about brutal honesty, that's exactly what I'm talking about.
Mm-hmm.
Has everyone here flown on a plane before? I see. I think everyone nodded yes. So when you get on the plane, you probably recall at some point they kind of tell you, hey, sit back or lay back, enjoy the flight. We're going to arrive at our destination at such and such time. If instead of getting that announcement, the pilot told you, hey, so I'm going to try to land the plane. I think we'll get there at this time and hopefully we land. Would you feel comfortable staying on that plane? I see a few people didn't respond completely. I saw a lot of shaking of the head. Juror 752, would you feel comfortable staying on that plane?
Not knowing, I mean, I like to know where I'm going, and if there's uncertainty, I'm going to be questioning it, you know, trying to see if it gets some answers. Like, I don't like just sitting there blindly and just following. I'd like to see what's going on.
And I appreciate that. Juror 922, how about you?
I prefer my pilot to be competent and confident, I would say.
And I think those are both very fair answers. So if you have the choice and you could get on a plane where the pilot says, I can for sure land this plane, and the other plane, the pilot says, I might be able to land it, which plane are you getting on? And I'll ask Juror 951, which plane would you get on out of those two?
The one, the pilot being confident of getting to our destination.
And I know that might seem like an odd analogy, but when we ask you to sit here, and this goes back to the brutal honesty, because the defendant, Chad Daybell, is entitled to a fair trial, as is the state, we want to make sure that we have jurors that can say, you know what, I can sit here, I can weigh the evidence, I can be fair and impartial, and essentially I can land this plane. I can do what's being asked of me. And so as we go through these questions too, we want you thinking of that. Can you be, keep an open mind and weigh the evidence and give it the weight that it's due? Because that would be your job as the jurors here. So I have a little boy, and in the mornings when he wakes up, if I ask him, what do you want for breakfast? 9 times out of 10, it's cheesy
Here we go,
eggs.
cheesy eggs, people.
But his cheesy eggs are made a certain way. We have to do the eggs, we have the cheese, we have the milk, and we have the salt and pepper. And honestly, he likes extra cheese. So that's his recipe for the cheesy eggs that he wants me to make. And if I vary it, he's not necessarily happy. But do any of you have that experience where, whether it's a kid or someone in your life, there's some kind of a recipe that they like made just a certain way? That's just how they like it. And Juror 1004, have you had that experience?
Definitely similar with having 3 kids now and getting older, but yeah, my 3-year-old, she'll eat just about anything, but she's very particular about certain things. So yeah, I can relate.
And Juror 909, how about you?
Mainly with kids, but I don't know that I've ever had anybody that was super specific. It was either I don't want a kid or do like it.
Or I like it. And if you're around someone like that and you're given this recipe, I think sometimes it's easy to say, you know, if I changed it this way, if I added this, or if I took this out, or I made it just a little bit different, it would make more sense, or I would like it better. When you're sitting here today, and the judge did give you one jury instruction today, if you're selected, you're going to hear a lot of jury instructions as you go through this. And some of those jury instructions
toaster strudel does sound really good right about now, Tony. I won't lie.
So
it does sound nice.
Like a recipe the judge is going to lay out. The state has to prove.
Damn you, Tony, for saying toaster
strudel.
strudel.
The state doesn't
now
have
I might have to go buy them at the store.
And the state has to prove all of them.
You're a bastard.
And sometimes it's easy to look at those and think, well, this doesn't make a lot of sense. Why don't they have to prove this? Or maybe they shouldn't have to prove this. But we have to make sure that you can follow that recipe or that jury instruction as given by the judge. Does anyone have concerns that you wouldn't be able to follow the instructions given by the judge, or that you'd be tempted to modify it. Anyone have that concern at all? Okay, I don't see anyone saying they have that concern. So with those, when we talk about the recipe and the instructions, as I said, the judge will lay out the elements. And sometimes it might not require an ingredient or an element that you think we should have to prove.
Can we just give a little bit of a
when you're dealing with
thumbs up to Tony, our mom,
jury instruction,
who does the thumbnails and otherwise helps me in many ways? Tony rocks. Kestrel rocks. All of our mods rock.
Isn't going to be that we have to prove the actual
Kestrel
laws.
sometimes tries to get me in trouble, but that's okay.
We have to prove that they were part of it or that they committed the murder, but we don't have to prove how they went about it. Does anyone have concerns with that, with following the court's instruction on that? So if the state was able to meet the burden of proving that they did it or they were part of it, of the murder, would anyone have concerns if the state didn't prove the actual cause of the murder, if that's not one of the ingredients? I don't see anyone saying yes to that. And again, you previously heard the judge give an instruction regarding conspiracy and talking about it being an agreement by 2 or more persons to commit a crime. So I'll tell you, I have some older brothers, and 2 of them were pretty close in age. And so my mom will tell stories about the 2 of them because they would get into shenanigans together. And the 2 of them, one of the things that they would do is the older brother and the younger brother would get together and they'd come up with a plan. And oftentimes the older brother wanted the younger one to carry it out first. So they came up with a plan to jump out of the barn door. So as part of this, they come up with the plan, they go into the barn together, they climb the stairs, and the younger brother jumps out. Well, he gets hurt. So the older brother doesn't follow. But they both had talked about going to do it. They both had the intention. So ultimately, they both were involved in that. So when we talk about a conspiracy and an agreement by 2 persons to commit a crime, you'll get instructions regarding the agreement and what qualifies as an agreement and what an agreement actually is. And again, that will come from the court. But it will talk about that only one person in that agreement has to do something that is referred to as an overt act. So only one person has to do some act to further that. Does anyone have a problem? Because let me back up a little bit. You were also instructed by the court that there are co-conspirators that you may hear about, and you're not to worry about what's going on with them. But what you will hear evidence is of some of the actions or the allegations that the state has, and you'll hear evidence regarding those actions of the other co-conspirators. Does anyone have a problem knowing there's an agreement and only one person has to do an act in furtherance? Does anyone have concerns that person A may not have done the act in furtherance of the conspiracy and person B did? Does anyone have a problem then essentially holding person A still accountable? So like the brothers planned, both of them climb up the stairs, but only one jumps out the window. But they both planned it. They both were going to do it. Anyone have concerns about that at all? Thank you so much for your time this morning. I have no further questions.
All right, thank you, Ms. Wade. Mr. Pryor, you can conduct voir dire for the defense.
Good morning, ladies and gentlemen. Voice distracted. I don't know if that's something I need to do this or. I'm here today to ask you a number of questions. And I don't want you to infer from any of those questions that there's a right or wrong answer.
There's a right or wrong answer, people.
Just talk and get to know each other and sort of get feelings about how we feel about a variety of topics. And again, there isn't any right or wrong
answer. All right,
answer.
Which font in the Century family do you guys like best? Do you like Century Expanded, New Century School Book?
Ask you a question.
Century School Book. Which Century family font do you like best?
Many years ago, when I was a much younger man and much skinnier, I was in college, and I was having to do jury service, much like what you folks are doing. And the attorney at the time, and I remember this, and I bet maybe it was the reason I became a lawyer, I don't know, had an impact. Because the attorney stood there and said, is there anybody who just doesn't want to be here today? And I thought that was a very interesting question. And I didn't think long, and I raised my hand. Now, I'm not trying to dodge my responsibility and my civic responsibility to be a juror. That's not really what I was doing, because I appreciate that. And
Century School Book?
we have a law enforcement officer who's sworn to uphold the law and to do his best to follow the rules.
Yeah, it works
and
for
yet,
me.
I can tell by the distress of having to be here, and I can see it on his face. There's concern.
All right, Century School Book
And
will
so
work.
I really want all of you, and the state talks about brutally honest, and I'm going to touch on that a little bit later, but I need all of you to be honest with me. And you're not going to hurt my feelings. I can't speak for the folks over here, but I know that no one's going to take offense to that, because this is a serious case. And it's a complicated case. And we need all of your attention. We need it to be focused on this. And it's not going to be imputed to you that you're not doing your civic duty. And it's not going to be suggested that you aren't, faithful to our country, or all of those things that are at least important to me, but important to all of us. That's not the case here. But in all seriousness, I guess we have to really be honest.
Why is it not in my
about
Microsoft Word?
I'm
Is
not
a
gonna
good question
use
right now, though.
brutally. I've got a strange adjective to attach to a statement of honesty, but that's their issue, I guess. But again, I'm gonna ask this: is there anybody who just feels that what's going on in their personal life is so profound and so complicated, they just don't think they could, in all reality, do this very complicated job? Hold up your cards, please, if you feel that way.
I want to start by making the cover page look pretty so I can put it in the
We're
right
here
format,
today, and you've heard the allegations.
So I want to start by
You've
writing
heard
it
what
in the
he's had to
right
say about the
formats and stuff, so
charges
that's
that
why
are
I'm
against
asking.
Mr. Daybell. Is there anybody here who, at the present time, based on what the charges are alleged, believes that Mr. Daybell is guilty right now? At the present time that he's guilty right now?
Yeah, unfortunately,
1057?
the
Okay,
Supreme
and
Court says
1004.
century, so guess what font we're writing in?
And I guess I'll inquire, 1057, is there any chance that you're going to be able to change your mind in that regard? Or
Yeah,
are you pretty firm in your belief?
our choices are century. So yeah, that's what we're doing now.
I thought that, and I answered correctly.
Okay.
I answered honestly.
Okay. And 1004, law enforcement officer, and I can understand that.
I definitely would want to weigh the evidence, weigh dissidents.
Okay, all right, thank you. Is there anybody here who can't sit for long periods of time, other than me? Is there anybody who is unable to sit, or because of any kind of health concerns, you're not able to, okay, 922. You have some concerns about
Yeah, it makes
sitting
things
for long
real easy,
periods of
right?
time?
I
Yeah,
know
makes
I'm
things
young,
exceptionally
but
easy.
I have had a kidney stone in the past. I'm already sitting here wishing for a bathroom break. I'm not gonna lie. Sometimes it's just, health concerns. It's difficult.
Do you need to take, and I don't want to announce this, but do we need to take a break right now?
Not on my account only, but if there's other people who need it.
Judge, do you think you want to take a short break?
I do, actually. Looking at the time, sometimes we lose track of how long these jurors have been captive before we get breaks and other court staffs. So it is late in the morning. Let's go ahead and take our mid-morning recess.
Oh, good, we're taking a break.
Okay, and we'll conclude then with.
Good timing for me, because I just finished doing my legal research for the moment. I'm starting to write. So it's good timing for me. It's a good mental break.
Try to come back in about 20 minutes.
All right, please.
Show us the font? Well, first of all, I have to download the font, which apparently is a whole thing for some reason. But yeah, it's fine. It doesn't matter because I don't have any choices. So yeah. Okay. So yeah. I mean, I don't want to go overboard, but I do want to start writing it in the right format because you know, it will help me think in terms of like the outlay. So I don't want to go crazy, but I do want to like, you know, get the basic parameters of the way it looks aesthetically right, so it will look right as I'm sort of writing it rather than fixing it at the end, I think. So anyways, that's the way I've decided to go. Okay. Clean school book is clean and slender. Well, I just downloaded the new Century school book because apparently I didn't have school book installed for some reason, even though it says I'm supposed to. But I don't have it for some reason. I don't understand why, but that's okay. All right. Okay, we are picking up with the words of Chad Daybell. We are currently in the book The Great Gathering, which is book 1 of the Standing in the Holy Places series, which is his version of the Left Behind books, basically. When we last left the action, the U.S. government was encouraging everyone to have a chip installed in their hand. Tad, our protagonist, had just been informed by his workplace that his workplace was making the chip mandatory. We pick up with the excitement. Come on. Come on, Kindle. There you go. Okay. Great. The employees filed out, but anxiously Tad waited for Ken to pass by. "Can I talk to you for a moment?" he asked. "Certainly," Ken said. "Come into my office. I thought you might have a question or two." Once they were seated in Ken's office, Tad asked, "As an active member of the church, how do you justify this?" Ken smiled sadly. "This was a very difficult decision for me until the board of directors said they would fire me if I didn't comply. I had to put my family first. I have 2 sons on missions right now. If I lose my job, how would I support them? Plus, I'm the bishopric. And how would the ward members feel if I lost my job and had to use fast offering money to feed my family? As you know, the government now won't even process a person's unemployment benefits without the chip." "Even then, I still don't think I could do it," Tad said. "This isn't a money issue, it's a moral issue." Ken stood and went to his office window that overlooked the City Creek Center beautiful outdoor gardens. "Tad, look at this wonderful area the church has built to keep businesses here in downtown Salt Lake. Do you really believe the church leaders don't realize that billions of dollars are going to be lost if the church members and their businesses refuse to get the chip? We'll go from being one of the richest churches in the world to one of the poorest." "There must be a way around it," Tad said. "I can't see the church giving in for financial reasons." Ken shook his head. "The costs are too great. If the church leadership really are going to take a stance against the chip, I feel like they're asking too much of us. They'll destroy the church." Tad struggled to absorb what he was hearing. He'd be sure Ken would be the last person to succumb to the pressure. "So I guess this means you're going to get chipped?" Tad asked. Ken held out his right hand and Tad could see the tiny mark. "The mark of the beast, one might say." "You've done it already?" he asked. "I got it on Friday and recommend you do the same," Ken said. "There's no reason to tell Emma. What she doesn't know won't hurt her." "Wow, I don't want to lie to Emma." "How is it a lie?" Ken asked. "You do dozens of work-related tasks every day you don't tell Emma about. Just consider getting the chip to be one of them." Tad didn't respond and Ken slapped him on the shoulder. "You have a bright future with this company. I expect at least 2 of our top employees will leave because of the announcement, and you're in a great position to fill one of the spots. I bet you double your salary within a year." Tad was surprised. "Do you really mean that?" "Definitely. The members of the board of directors have mentioned your name several times. They're impressed with you. Don't throw away this opportunity." We are reading from Chad Daybell's book, The Defendant. The defendant wrote a book. He wrote a series of books. We are reading his Left Behind clone. Chapter 6. Tad went back into his cubicle. His back muscles tightened up from the stress. He weighed his options and he was getting the chip seemed to be the only realistic answer. With one simple procedure, he could guarantee financial security for his family. I probably won't even notice the chip most of the time, he said to himself. As he pondered his dilemma, the phone on his desk rang. He checked the caller ID. It was his Grandpa North's number. His grandpa called him occasionally, although this phone call seemed particularly timely. "Hi, Grandpa," Tad said into the phone, forcing some happiness into his voice. "How is everything?" There was a brief pause, and then he heard the voice of his father, Roy. "Hi, Tad. It's Dad. I'm calling to let you know that Grandpa has passed away." Tad was briefly speechless. He couldn't believe it was coming right on top of the meeting they had just had about the chip. "Tad, are you there?" Roy asked. "I'm here, Dad. I knew this was coming, but I'm a little shook up, I guess." "We all are," Roy said. "I came from St. George last night to be with him, and when I checked on him this morning, he had died." It looked like he went peacefully in his sleep. "How can I help?" Tad asked. "We're going to have a funeral on Wednesday with a viewing tomorrow night. I hope you can get off work on such short notice." "I should be able to," Tad said. "I'll go check in with my boss right now." "Good. I'll talk to you tonight." God smoke Grandpa. If Grandpa hasn't been assassinated, it would mildly surprise me. That's my expectation. That Grandpa's been knocked off because he knows too much. After hanging off, Tad went to talk to Ken, who was very understanding. "Yes, certainly take the next couple of days off. Thank you, my grandpa meant very much to me." Ken nodded. "When you get back, we can talk more about your future." During Grandpa's North funeral, Tad felt a bitterness building inside of him. The other family members were hailing Grandpa North as a wonderful man, which Tad readily admitted he was, but they were all focusing on his refusal to accept the chip. Over and over he heard, he died following the counsel of the prophet. Tad couldn't help thinking, well, that's true. But if he had gotten the chip, the government would have paid for his chemotherapy and he'd still be with us. Then Tad mentally would kick himself, knowing his grandpa had stuck to his principles to the very end. After the graveyard-side service at the Orem City Cemetery, Emma asked if they could drive down to Springsville to visit her parents. When they arrived at the house, she saw Emma's brother Doug was also there. As they entered, Doug was at the kitchen table talking intently with his father Mark. They paused their conversation and offered Tad their condolences about Grandpa North's passing. Then Doug said, "I'm glad you two are here. I was just telling Dad about a project I'm helping set up in Hobble Creek Canyon as part of my new calling as the Stake President Preparedness Coordinator. I think you two would be interested in what we're doing." "Tell us about it," Emma said. "Well, we've been storing tents and supplies in buildings near the Jolly Ranch campground. I'm not sure of all the details yet, but I really believe the campground is preparing as a refuge of church members in case of a major emergency." "What kind of emergency?" Tad asked. "We hardly seem to be in a situation to evacuate. The economy is booming right now." Doug shook his head. "Tad, we both know this economic boom is mostly based on people spending their chip money. What happens when all the money is spent? The economy could easily collapse on itself. And what about those who haven't received the chip? We'll be the ones who get shut out by the government if things get bad." Tad didn't answer immediately, knowing Doug was right. "So what is the plan?" Tad said. "Gather into the mountains?" "If necessary," Doug said. "The church is quietly preparing for such an event, and I think at the right time they're saying more about it publicly." When will we know if it's time to gather?" Emma asked. Doug shrugged. "I expect the prophets and apostles themselves will direct us through a proper priesthood channel." They have proper priesthood channels? Okay. "The refuge is being prepared under the direction of presiding bishopric." That's the second time they've used that term. Apparently bishopric is a title. I don't know what a bishopric is. Is anyone here speak Mormon? Does anyone know what a bishopric is? bishopric. Bishopric. What is a bishopric? Is it like an archbishop? That sounds that's kind of what it sounds like, but okay. "And there being several refugees being prepared throughout the West. They're even hauling wheat from people's food storages, collecting towels and setting up cows and chickens. Each stake will have a gathering place. A bishopric is just the local group of men leaders in a church. So is it like an informal thing? Is it like an informal thing that it's just like a leader of group, or is it like, okay, whatever. Emma let out a sigh. No, they're called to it. Well, so is everyone, apparently. Everyone's called to everything in the Mormon church, don't you know? The bishopric is the leadership of a local congregation consisting of a few people, including a bishop. So the bishop isn't even the leader of his own congregation? What's the point? That sounds like a bad deal, man. That sucks. You're the bishop and you're not even the leader? That's some bullshit. Okay. Emmett let out a sigh of relief. I'm so glad to hear the church is looking ahead. I've been worried about what we'd do if things got worse. Tad felt wilderness surge again. Even 2 weeks ago, he would have been very interested in the plans, but the combination of his work situation and Grandpa's North Desk had left his mind reeling. Let's not get too carried away, Tad said. Emma, we're going to be fine. All the church has done for nearly 200 years is scare everyone into thinking a disaster is around the corner. All I hear is, get your food storage, get your food storage. I'm certainly not going to give up a good job just to run off with some doomsday group. Doug shook his head. I would hardly call the church a doomsday group. The general authorities have been very cautious not to call a panic among the members of the church. You can look at it however you want, Tad said, but tell me this, Doug. If you take off into the mountains, who's going to pay your mortgage? That's a good question, Doug said. I've thought a lot about that. I wish I was like Mom and Dad and paid my house off, but I didn't. But I think if I left my house to join a mountain camp and stopped making payments, the bank would rightly foreclose on it within a few months. I'd be all right with that because it's the bank's legal right. Then the bank could sell the house at fair market value and probably even get more money out of it than the amount I owe them. Well, ideally, but probably not. Bishopric is the entire office, not just the bishop? Oh, okay. Oh, so it's the name for... All right, so it's named for like a collective thing. Okay. Tad pondered deeply. Then what about credit card debt? That's why Becky and I have avoided using credit cards, because who knows what the credit card companies would do? Well, they would sue you and get a judgment against you and start trying to collect assets. I mean, it's an unsecured debt, unlike a mortgage. A mortgage is a secured debt, right? It's debt secured by the house. That's the point. So when you default on the mortgage, they take the house because it's a secured loan, much like a car loan. The loan is secured by the car. So what happens when you don't pay? They take the car. A credit card is an unsecured loan. So what happens when you don't pay? Well, there's nothing for them to take because it's unsecured. So what do? They sue you and they get you to give them money and stuff. So that's how that works. Yeah. With a mortgage, you have your house, the bank takes as collateral. Incidentally, by the way, of course, in the event that your house is not worth as much as the mortgage, they still get to sue you. So it's not like a one-for-one trade. If there's a surplus, they have to pay you the surplus. And there's a deficit, they get to sue you and take money from elsewhere. So it's a secured loan, and the house is the thing that secures it, but they can still go for you for any unsecured amount, and they have to pay you for the balance. But with credit cards, you don't really have any collateral to settle your debt, especially if your house has already been taken. Well, the credit card company probably wouldn't be able to get your house as part of the remedy because of every possible reason. And even if they could, the bank would still have primacy on the loan because that's the nature of a secured debt, right? You can read about that in the bankruptcy law, for example. Secured debt beats unsecured debt in debt hierarchy. And there's other things beyond that too. But yes, so even if the credit card company could somehow get after your house, they would lose to the bank because the bank has a secured loan and they have an unsecured interest. So their interest is necessarily subservient to the bank's, as long as we're learning something about how loan defaults work. That's also true in bankruptcy, by the way. And you can go read the Bankruptcy Act, which sets out like different levels of different kinds of things. But yeah. All right. I'd hate to be dragged out of the church camp and thrown into prison simply because of credit card debt. Well, that's not possible because we don't have debtors' prisons, but okay. I don't know if we reach that point, but I could see the credit card companies demanding it. Well, they can't because we don't have debtors' prisons. What a tragedy that would be. Tad was listening closely, trying to sort it out in his head. But don't you think the church would get everyone enough notice about the camp so members could sell their homes? Doug shook his head. That wouldn't make any sense. There'd be a sudden glut of homes for sale, and people wouldn't get fair value. Probably true. It would throw the whole housing market into a tailspin. Possibly. Don't forget the church has already been through this before. When the Saints were given a deadline to leave Nauvoo after Joseph Smith's death, they couldn't get anyone to give them fair price. Some of the church leaders couldn't even sell their homes or sold them for a ridiculously low price because the mobs knew all they wanted to do was wait for the Saints to leave and they would have to sell their house. Yes, well, you know, if you're desperate to sell, then it does somewhat mean that the buyer is incentivized to not offer you as much, right? If I know you have to sell, then I can offer you anything because you have to sell. So, yeah, I mean, I'm obviously going to take you for everything you're worth. Because that's logical. Tad frowned. We live in a different world now. We aren't so uncivilized that people would take someone's house like that. We totally, absolutely would. Yeah, absolutely would. I mean, if you decide to sell your house and everyone sells their house at the same time, so supply has gone up relative to demand, what happens when supply outpaces demand? Price goes down. Because there's more of it. So the very act of everyone putting their house on the market at the same time changes the fair market price. Plus, if you feel like you're compelled to sell, that goes a long way too. Doug raised his eyebrows. Do you really believe that? I feel the exact same thing would happen, except it would be our own unscrupulous members waiting to capitalize on the situation. Well, I don't know if it's unscrupulous or not. It's just the economic reality. Here's a thing I don't like anymore. It's value to me. Like, something's only worth as much as someone's willing to pay. And like, your subjective value goes a long way because it's what are you willing to sell it for? Right? So if your subjective value of the thing has decreased, then they'd be a fool to pay you anything more than that. Even if the fair market price is worth more. I mean, because a person can ask more than the fair market price. It doesn't mean anyone would be willing to pay it, but you can do it, right? You can put your house on sale for any price you like. You're under no particular obligation to sell your house for the fair market price. If you want to sell your house for much, much more than the fair market price, then, you know, fair enough. And maybe someone's willing to pay it for whatever their subjective reasons are. But yeah, I mean, you know, I don't know what we're talking about. But you're missing the point. I believe the call to go to the camps will be a test of faith. Will people really be able to sacrifice their material possessions to follow the prophet? I think fewer people will do what you'd expect, probably. So you're saying you would throw away all the equity you've built up in your home the past few years. Well, strictly speaking, he's not doing that because, again, he's entitled to the equity as a matter of law. And what about your furniture? Would you leave that too? If the prophet asked us to leave closely, I'd leave everything, Doug said, staring into the brother's eyes. Todd looked away. But what about all the LDS millionaires? I can't see too many of them giving up their fortunes. Who do you think bought all the property for the gathering places? Doug responded. In most cases, the refuge properties have been bought by wealthy LDS members who gave their land to the church. The same thing has happened with the purchase of electric generators and tents. None of the setup costs for the refuges are coming out of the church's tithing fund. The money's coming from private individuals who've been asked by top church leaders to contribute. If I was a millionaire, I couldn't think of a better way to use my wealth than to help prepare the refuges for the Lord's people. Tad shook his head. Doug, I don't quite believe you. You make it sound like the church has got this all organized behind the scenes. Well, I mean, yeah, probably. I have to say, I think you're getting a little fanatical, or even gone a little nuts. I mean, the idea that the Mormon Church, or for that matter, any organization, might be doing things quietly is not exactly like a completely foreign concept. You know, they want to do things in a more quiet manner to not let people know they're doing it. Yeah, so I don't know. Emma stared at Tad. She didn't quite know what to say. They had discussed similar things in the past, and Tad had always been supportive of doing whatever the prophet asked. Finally, Doug said, Tad, maybe I didn't explain what I meant very well. No, it's all right, Tad said. I'm sorry. I shouldn't have said that about you. I'll go check on the kids. Tad waited outside, and Doug asked Emma, has Tad been talking this way for long? Emma was on the verge of tears. No, but the past couple of days he's been very distant. Well, that certainly doesn't sound like the brother-in-law I've known for many years. To be honest, I'm a little worried about him. Me too, Emma said. The conclusion of chapter 6. So you can see right away, like, where this is all going, right? You can see right away where this is all going. I mean, he's forecasted it very well for us, which I suppose is good. You know, the story has a very natural progression, and he's teed up for us very well where this is all going, right? So yeah, the Mormon churches, or at least some members of the Mormon church, are creating some camps in the mountains. The Mormon church apparently has said to its members, you can do it if you want, and apparently a lot of the members decided to do it. The other guy has been called from Guatemala to, I don't know, run the new center to create New Jerusalem, apparently, in Missouri, Independence, Missouri, apparently is where the New Jerusalem is. So our other character, who has been just rocketing through the ranks of the Mormon church somewhat unexpectedly, right? This guy who has some experience, but first was called to head the mission in Guatemala, which I understand is a pretty big deal for the Mormon church, because Guatemala is apparently one of the fastest growing areas for the Mormon church. So this guy has been asked to head this fairly important mission, even though he doesn't really seem to have a lot of experience. He has some experience, but not really enough experience for a mission of this magnitude. And apparently he's been asked to do that. And now, in our parallel story that we've been reading, he's now been asked by the church leadership to facilitate the building of the New Jerusalem, which apparently is in Independence, Missouri, and then, I suppose, somehow get the Guatemalans out of Guatemala and to Independence, Missouri, for the New Jerusalem. So that's super exciting. Is this a book I read to Legal Vices? No. The thing I read to Legal Vices was a text message story. It was a different story that Chad wrote to his wife. He wrote a short story, 2 chapters of a story, and he sent it via text message. And so we read the messages about the loin fire and so forth and so on. It was hilarious. Good times. Yeah, it was an interesting read, with the loin fire and the spirit of God being a cock block and other things. It was an interesting thing to read. Chad Daybell is a bit of a prolific author. He wrote this series, which is 5 books, and then he wrote a different series, which was also like in the same genre of like post-apocalyptic fiction. That's 3 books. So he wrote at least 8 books in the post-apocalyptic fiction genre, along with other books. He's written quite a few books, Plus, he wrote the text messages about the loin fire. He's a very prolific author.
All right, great.
If you can walk to the courthouse, you probably should. It might be interesting to go there in person and watch. It looks like there's room. I'd be happy to be with Legal Vices again. He's a cool guy. Maybe I'll send him a message and see if we can work on like joint broadcasting it or something. I don't know. Yeah, I'll let me send him a message and see if he has any interest in like trying to work out some sort of joint streaming schedule or something.
Defense, you can continue, Mr. Pryor.
I'll send him a Twitter DM.
Ladies and gentlemen, I'll move on a little bit. Is there anybody in the jury pool today who knows any of the parties that are here today? Any of the attorneys? Number 10004.
Yes, sir. I'm familiar with Ingrid Beatty. I've worked cases with her again.
And would you just, without too much specific, identify which one you say is Ingrid Beatty?
He's the blonde.
And there's no doubt that the two of you know each other.
No, sir.
And the fact is you've worked on cases with her.
That's correct.
And you're familiar with her.
Yes, sir.
And you've discussed it. And the fact that you've worked on cases with her, is there even the slightest possibility that you would put more weight to anything she said as opposed to, let's say, me?
In honesty, yes. She's a very good investigator.
They don't let the public in jury selection?
Okay.
Oh, okay. Well, never mind then.
Me testify and, or not testify, excuse me. If I were to offer some evidence, Ms. Beatty was offering evidence, and it would be, and it's human nature, you'd agree with that, right?
In truthfulness, yes, sir.
That would. And in fact, you would give Ms. Beatty more weight and pursue that situation. Is that fair?
I think that'd be fair, sir.
Okay. And thank you for your brutal honesty, I guess. I'd use a different word. I guess I'd say transparent. Brutal always sounds so difficult to me, but anyway, I'm going to move on a little bit, and thank you for that disclosure. I appreciate that. Part of this case, so we are going to see some pictures. Very, very graphic pictures. I want to tell you that I'm involved in this case. When I look at these pictures actually hurt my heart. Difficulty is this.
I sent a message to Legal Vices and see what he says. I'll also send a message to Donnie on direct as well, because she might be interested too. They probably have an agreement already between them, if I had to imagine. I might be stepping on their toes, but it doesn't hurt to ask.
Is there anybody, because they look at these
I won't take it personally if they already have an arrangement.
And you have the same reaction that I have. These pictures truly hurt my heart, and it's painful. Is there anybody who's going to be able, who's going to say, these pictures hurt me so bad that I have to blame him, regardless of what the evidence may show or otherwise? Is there anyone? So, juror number 791, is that your number?
Yes.
Okay. I thank you. I see your reaction.
I'll just send a message back to.
Are you trying to be strong, or is that something that you think is going to have an impact on
It's.
You want to sit in when they let the public in? It's totally up to you. It's totally up to you if you want to or not. I mean, it's a 10-week commitment. So, if you want to go for some days, I think it would be interesting.
I'd like to think that I will.
Especially like if Chad Daybell takes the stand, that'd be really cool if you were there to see that. That'd be interesting. I doubt he will, but just in case.
Appropriately. I hold myself to a very high standard, and the nature of the case, I would want to be very fair and impartial, not taking anything lightly. Due to the nature of the images that might be shown, and will probably be difficult. I can't say how I'll necessarily react to them, but I don't think I will let it impact my ability to judge.
And I appreciate you taking the time to talk about this. As you can understand and agree, probably that looking at very graphic pictures can have an impact on it. But we need to be honest about that.
Okay, so this is sort of apropos of nothing in particular. But if I'm understanding correctly, apparently Scotland recently passed some sort of hate crimes act. And there's been a dispute as to what exactly it deals with and whether or not it prohibits misgendering people. So a person says to me, a biological male says to me, I'm a woman. And it's like, okay, no, you're not. And so is that illegal? Can I say that, or is that illegal? So some guy who I'm going to assume for the purpose, some guy named Sam Foles, who describes himself as a barrister. So I'll assume that he knows what he's saying. He says some myth busting on the Hate Crimes Act. Okay. Number one, misgendering isn't a criminal offense save for extreme circumstances. I'm not encouraged. Number two, the act's aim is to stop people using a legitimate belief as an excuse to abuse or threaten. Okay. Number three, the act explicitly protects freedom of expression. But does it though? Yeah, I'm not super encouraged by that attempt to walk back the Hate Crimes Act. It's not a criminal offense except in extreme circumstances. Yeah, I don't know about that one. Yeah. Anyways, back to the trial selection.
As I get older. But my recollection, if I recall, is that you're the juvenile corrections person. Is that correct?
That's correct.
Okay. And I would imagine you do have to deal with those things, and you have to be able to compartmentalize and separate your feelings about certain things and look at things in the big picture. Is that fair?
That's fair, yes.
Okay, I'm going to switch gears a little bit, just a little bit. And I want to talk a little bit about bias, how we judge and view bias. And I think what I'm going to do, and please forgive me, officer, I don't mean to keep picking on you. And I appreciate your being very honest about that. But when my recollection of yours, and correct me if I'm wrong, is that you were a traffic officer. Is that right?
I'm a patrol officer.
Patrol officer. I used the wrong term. I'm sorry. Now, as a patrol officer, while you're driving down the road and you find someone who's breaking the law, like speeding, and you pull them over, okay? Now, I have a difficulty is that in my prior life as a lawyer, when I got pulled over by a police officer, I had a habit of just saying, yes, I was speeding, and then they would ridicule me with the particular law enforcement agency that I dealt with. They said, you're a lawyer, why are you admitting the truth? And then I said, well, it's because I was speeding. And I was being very honest about things like that. Is that your usual experience, that when you pull people over for speeding, they immediately acknowledge that they were breaking the law?
I'd say it happens more than not, but there's definitely some that
Try to get out of it.
try to get out of it, yes, sir.
And there's various reasons people try to get out of this, right? And there's various reasons that people may not be particularly honest about things, right?
So I agree with that, yes.
And then one of those reasons could be they have an agenda.
That'd be fair to say, yes.
Okay, and that doesn't just apply to regular citizens, it applies to everybody, right?
I agree.
It applies to doctors, police officers can have an agenda, they can have a desire that a particular case goes a certain way. Do you do that?
I definitely have biases, everybody does, I'm not gonna say I don't. I definitely, I think just being professional, I remove those things, I can maybe assume a situation is gonna go a certain way or assume something happened, but I also know that if I'm gonna arrest somebody or if I'm gonna write somebody a ticket, I need to be able to prove beyond a reasonable doubt that in fact, whatever the violation or crime that we're dealing with happened.
And you would agree with me that if a like in your, I'll just stick with your profession, I'll get to some of these other folks, but in your profession, if someone has a bias, that's a troubling issue, isn't it?
It can be if you let that interfere with making decisions, in a particular case or something like that. Everybody, I would agree, has biases. Everyone has different opinions about book theory, things like that. It's when it becomes an issue is when that those internal feelings, internal thoughts based on whatever experience you had in life, things like that. When you start to allow those to actually dictate your decisions, that's when we would have an issue, especially in my profession.
Or you make a predetermined decision that this is what the results you want. That's concerning as well.
It could be, yes.
And that should never happen in law enforcement, should it?
When it comes down to making actual charges and arrests, no. There's times where it's not based on experience. There can be certain perceptions from a situation that, based on training and experience, can lead me in a direction of either proving something or disproving that an event occurred or details of it occurred or not.
Okay. But the reality is that you shouldn't have that tunnel vision. You should look at the whole picture rather than trying to pursue an agenda. Is that fair?
I would agree, yes.
Okay. It's inappropriate for someone in a position of authority to inject their opinion and then pursue a matter because that's the result that they desire. Would you agree with that?
I think it's solely on that, yes.
And that's bias, right?
Yes, sir.
Okay. Thank you very much for your answer. Now, the prosecuting attorney talked a little bit about conspiracy. Is there anybody here who doesn't know what the term agreement means? Please raise your hand if you don't know what an agreement is. Okay. Please raise your hand if you don't know what the term agreed means. A-G-R-E-E-D. Does everybody know what agreed means? Okay. I'm going to give you a little hypothetical. I'm going to inject one of you in this hypothetical, okay? And I haven't picked on Juror 951, so we're going to pick on you a little bit. Is that okay? And if it's too much, tell me, please, okay? This isn't to put you on the spot. We know each other, let's assume we know each other, and I go up to you and I say, Juror 951, it's a beautiful day out today. I'm going fishing today. Okay? And then I go off and go on a fishing trip. And then suddenly I look over across the pond and you're there fishing. And I didn't know it. Do you believe that's an agreement to go fishing together?
Yes and no.
Okay. And why do you say that?
Yes, you had mentioned that you were going to go fishing.
Okay.
But I've never agreed to go fishing with you.
Okay.
And so if you were to be there fishing and I just happened to come along and I start fishing across the pond, that wasn't an agreement to go together.
Right. So you, in that instance, you would say there is no agreement. Okay, and Juror number 922, you had an interesting nodded. And I guess I'd like your
I appreciated Juror 951's answer of both yes and no, but
okay.
Recognizing that, I don't know, that kind of social situation is awkward in one part, and to have an agreement, you really need to talk about it beforehand.
Right. And when you say you need to talk about it, does it have to be laid out specifically?
No, I don't believe so.
Okay. And what are your thoughts on that, Juror number 752?
There wasn't an agreement.
Okay.
They just showed up at the same time, but yeah, nothing was agreed.
Okay. And let's say as a result of the fishing, let's go a step further with this. As a result of this wonderful fishing trip that I went on, I look upon or across the pond, and the other person fishing, and we're going to let you off the hook today. So that's a terrible expression. But we're going to let you off the hook today, Juror 951, and we're going to say it was somebody else. Okay. And let's say that as a result of both of us being out there fishing at the same time, I'm not catching anything. But boy, the other person across the pond has a stringer full of like 10 trout. And juror number 1057, the limit on trout that day was only 6. And unfortunately, that juror, that person was breaking the law. And along comes the fish and game officer. And this fish and game officer says, you broke the law and I'm giving you a citation. Okay? In that situation, am I responsible for a citation as well because I'm fishing on the other side of the pond?
I do not think so.
Okay. Juror 1048, should I be getting a citation because I was fishing on the other side of the pond?
No, if you didn't reach your limit or exceed your limit, then no.
Well, what about just the fact that maybe we were both there fishing together and there may have been, whether there's an agreement or not, does that make me guilty?
Judge, may we approach?
Yes.
And this is all sorts of fun. Super fun and exciting. They're having an argument about whether he's misleading the jury or something at this point. It's like, okay, whatever. He's trying to ask them about conspiracy is what he's trying to do. He's trying to ask him if it's fair that you're charged with something else because you're in agreement with someone else. This is exactly what he's trying to do. He's trying to ask, is it fair that you had an agreement with somebody to do something and they did something and you didn't and you're charged? Is that fair? That's what he's doing.
Now that's good. Whoops, I'm sorry. Oh my gosh. Oh, maybe we should start.
All rise. Court's good in session. If you see them. They're going to try to start with no choice. All right, just back on the record here, the court will note for the record, we had a sidebar concerning the scope of voir dire. The court generally does disfavor hypotheticals, and I've notified counsel of that, considering Idaho Criminal Law 24B. So, Mr. Pryor, I'll allow you to continue with your voir dire, but please refrain from further hypotheticals at this point.
I'm going to switch gears a little bit and try to avoid the hypotheticals. I think there's enough fishing stories. I need to know your feelings on how you would evaluate truthfulness, bias, whether people are telling the truth. I'm going to go back to my police officer. And how do you gauge, officer, whether someone's being truthful?
There's.
We got Century School book installed. We got that going for us.
Eye contact or lack thereof. There's also, through the investigation, whether an individual's statements are adding up with the evidence I have, corroborating statements, or other statements that disprove what they're saying. And there's lots of different ways you can detect lies or, pursue the truth, either do.
And as part of your occupation, you actually carry camera and recorder, is that right?
That's right.
Is that a standard practice?
For our department, yes.
Okay, and it's a good idea to record when you're investigating a crime. Do you agree with me?
It is.
Okay. Okay. And are there instances where you would not record something if you were involved in a crime investigation?
Per my department's policies, it's if we're interviewing suspects, victims, or pretty much any contact with the public, we record. So
All right. That's okay, thank you. So if we move on to the issue of trying to gauge how someone's being truthful or not being truthful. There are various reasons that people are untruthful, okay? And in line with trying to give everybody an opportunity to talk, we'll go to 909 because I haven't done anything with you yet. What sort of instances do you see where people tend to be untruthful?
When they have done something wrong.
Okay. So right off the bat, if they're trying to get away with something, they tend to be untruthful. Would that be fair? Yes. Okay. Are there other reasons people are untruthful?
Sure, little white lies.
Okay, little white lies, that would be to a spouse or something.
Sure.
Okay. Or it
I
could
need
be
a
bigger
brief
white
break,
lies.
so
Let's
I'm just
say,
going to put it on
one of the people in the relationship is having
full
an
screen
affair.
for a second so I can take a
Do you think
break.
people lie when they're in an affair with somebody else?
I'll be back.
Yes. Okay.
Need a second
And
to
I'm going to go
rest
to
my eyes.
922 and I'm going to work my way through. Do you think that people tend to be untruthful when they're involved in affairs or unrelated relationships they shouldn't be in?
Yes, of course.
Okay. And how do you feel about that?
About the lie itself.
Well, about the fact that maybe someone is trying to cover up an affair. Would you think that's human nature to do that if you're engaged in that conduct?
I'd say it most likely comes from a place of shame and guilt, at least in most instances.
Okay.
And I think we ought to be opposed to those feelings.
Okay. And what are your thoughts on that number, jury number 1048?
Did you restate the question?
Well, affairs, in terms of truthfulness. Is it a tendency for people to be truthful when they're involved in an affair?
I would say it's probably a tendency to be untruthful if they're involved in an affair.
And it's a way to sort of, like juror number 922 said, just hide your shame, or there may be other reasons as well, right?
I would agree.
But it's not uncommon that if someone's trying to hide a relationship of some kind, in your eyes, they would likely be untruthful about that, trying to hide that relationship.
I would say that's the case, yes.
Okay, all right, okay. Thank you very much about that. Your thoughts on that, juror number 951?
From a previous line of work, I would say that you restate that question.
Well, what are your feelings about if someone's involved in an affair? Is that something that you tend to see where they would be truthful, untruthful, or would they just basically have asked, they would say, oh yeah, I'm doing that?
I would say that when an affair is occurring, yes, they're going to be untruthful about it because they're going to try to hide what's going on.
Okay, all right. Folks, I want to thank you for your time. I appreciate it. I know this is the most comfortable thing to do, but it's necessary and it's important. And I think both of us, both sides, folks to my right here, the prosecuting attorney's office and myself, we're striving along with the judge to try to get an idea of what your thoughts are and beliefs are. And again, folks, there's no right or wrong answer. All of you have a right to an opinion, and I think both sides are going to respect. I know the court's going to respect your opinion. So I want to thank you for what you've done today and having to go through this. I hope it wasn't too terribly uncomfortable. Thank you.
All right, thank you, Mr. Pryor. That will conclude the group session of this voir dire examination. At this time, we're going to move on with individual questioning on different topics for certain jurors, and we'll have each of you return individually. So we'll start off smallest number to largest. And so if juror 752, you would remain seated, please, and the remaining jurors, if you'd all step out with the bailiff.
All right, great.
Thank you. Please be seated. All right, for juror 752, upon review of the questionnaire, I think the only topic that we need to address in further voir dire would relate to questions regarding the death penalty. Does the state agree or have any further question on bias or hardship?
I don't think so. No. No, Your Honor.
All right, any further questioning before we get on to the death penalty questions with this juror, Mr. Pryor?
Judge, I guess I just want to clarify a couple of things.
Okay, if you go ahead and make sure your mic's on, Mr. Pryor, we'll allow you some additional voir dire on the hardship.
Now, sir, you mentioned that there may be an opportunity for them to sort of cover your responsibility as the chief financial officer. Do you have an assistant or someone who works underneath you or perform the same duties?
So I have a controller underneath me that can do probably 70% of the work that I do. My only concern is it gets sequestered because I plan on working in the evenings, early mornings, weekends and stuff to cover up the remaining things. So.
And that was what my concern is because you mentioned that your hardship in the beginning, your evaluation, I'm going off of memory once again, but at the very end, do you have a copy of your evaluation or your questionnaire? Excuse me.
Yes, I do.
And if you return to the bottom portion, it's the very last page of your questionnaire, there's a comment there that talks about the fact that, please don't allow me to put words in your mouth, but seems to suggest to me that you intend to work while you were on your free time during this trial. Is that what I'm hearing?
If there's, like say we leave at 3:30 in the afternoon, I'm planning to work the remaining part of the evening.
And when you say the remaining part of the evening, what do you refer to?
So probably till 7 o'clock.
Okay.
I'm used to working long hours, so
okay. Is that your standard practice you're accustomed to working very, very long hours anyway?
It just depends on situations. If it's month-end quarter, if we're going through a sale of the company a few years ago, it requires me to work a significant amount of hours.
Well, I understand it's significant, and I'm not trying to argue with you. I'm trying to get a feel for whether or not I'm comfortable with you working, 5, 6, 7 hours after sitting in front of a jury and absorbing all of this information. This is not a reflection on you. Please don't take it. Please don't take it. What I have a concern about is that whether you're going to be able to put the necessary attention and focus. You have a significant job, very, time-consuming job. It's going to require a lot of attention. This is not just any run-of-the-mill job like me or anybody else. This is a serious position. And it requires a significant amount of time and effort to perform your job. Do you agree with that?
That is correct.
And what I have concerns about is that at the end of a 5, 6, 7 hour day listening to evidence, you're not going to have that downtime. You're not going to have that release to be able to absorb and maybe rest your mind, so that instead what you're going to do is you're going to go and work for, at least from what I'm hearing, 5 or 6 more hours on your job responsibilities and try to keep things afloat. Is that what I'm hearing?
There will be days like that.
Is it going to be every day?
I can't say it'll be every day, but there will be days where there's certain things come up that I would need to handle. So to me, my only concern is if I got sequestered where I wouldn't be able to have access to internet or anything else. And that goes on for like a period, yes, that would create some concerns.
And that's going to cause some concern in terms of your employment.
I mean, they wouldn't terminate me, but like say there's decision making that gets done that I would need to be part of, that I wouldn't be able to be part of.
But are you, the judge has purposely set a schedule for us from like 8:30 to 3:30 with time for some lunch to be able to do that. What I have a concern about is the court specifically set a short time, and I don't want to read into what the court suggested. It's not like for you to do that, but I would imagine the reason he's doing that is because after 5 or 6 hours of engaging in this sort of position to be a juror, you're going to need some time to recuperate from that. It doesn't sound like you're going to do that. It sounds like you're going to work.
I mean, like say, we all have responsibilities. Even when I come home in the evening, I got to take care of kids. I'm used to doing this. Like say, I don't want to say this is not possible. So it really is possible to do multiple jobs. And like say, to do this, I need to still work a couple of hours in the evening. This is what I'm accustomed to.
Okay, and you don't think that that's going to have any kind of an impact on your ability to effectively listen and do the job as a juror for 10 weeks?
I don't believe so. Like I say, my only concern is if we get sequestered, and that's a piece I don't have control of.
And if you do get sequestered, that is a significant concern. That
Correct, because I don't know how long that will.
I'm sorry, I apologize. Go ahead, sir. I'm sorry.
Yeah, no, that's my only concern. If I get sequestered, if it was for a week or 2 weeks, that would be concerning.
And at that point, it becomes a hardship. Would that be fair?
I would say yes.
And sir, don't take this as a personal affront. You can appreciate that I have a concern that you're going to be doing 2 jobs at a time when we're dealing with a case of significance. So, Judge, I'm going to move the cause in this particular case. I have a concern for his
response from the state.
Bigley, we would object to that motion. We believe that the juror has to continually express his understanding of the potential risks or any potential hardship serving as a juror. But he also understands that he has plans and he practice he can serve. So I have heard the juror say that he feels like it will actually be a hardship. He just needs to express concern. So at this point, we don't think that there's a cause to excuse this juror.
Okay, I'll just have a follow-up inquiry briefly here, Juror 752. There is a substantial likelihood of a time of sequestration without making any promises. That could be a week. There's a potential it could be longer though. And when you consider that, do you still feel like you're able to give your undivided attention to this case, even should a sequestration period take place?
I would say, depending when that week happened, if it was over a month-end week, it would cause concerns for me because, like I say, we wouldn't be able to close our financials, which we need to report at that time.
If that were to happen with bad timing, would someone else be able to assist in your employment responsibilities in your absence?
They, like I said, they would, but they wouldn't be able to complete the full job. Unfortunately, I have a controller that's been around about 4 or 5 months. She's not at the point where she can completely prepare the financials.
All right, but you're telling me you would be able to, regardless of your work commitments here, be committed and able to fully pay attention and consider the evidence in this case?
That is correct.
All right, I'm going to overrule the objection as to 752 in terms of expression of hardship based on his responses. And so the next matter the court then is going to address with you, Juror 752, is it in relation to that part of your questionnaire that's titled Attitudes Regarding the Death Penalty. Do you recall last week when you answered your questionnaire, thinking about and answering questions concerning the death penalty? Okay, are the answers you provided in that questionnaire still accurate and reflect the way you feel as you sit here today?
I do agree.
Okay. You indicated in your questionnaire you support the death penalty when you were given the option of yes or no, support or oppose. You said support. Do you still agree with that stance?
I do.
You also made a choice when given options about what most accurately represents the way you feel, and you said option C, which is, quote, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Do you still think that accurately represents how you feel about it?
Yes, sir.
Okay. Let me just ask an additional question there. If you are in favor of the death penalty, then do you believe the death penalty is appropriate or should be considered in every case where a murder has been committed?
When it's first degree murder, I do believe it should be considered.
Okay, and if the court were to give you instructions then about the death penalty, would you follow those instructions?
Yes.
If the court included instructions for some reason that you were not to consider the death penalty or instructing you that there are options besides the death penalty, would you fully and fairly consider those options as well?
I will.
All right.
Yes.
So given your views then, is there any reason for me to think your views would prevent or substantially impair your ability to serve as a juror in this case in accordance with the court's instructions if you receive those about the death penalty?
No, there should be no concerns at all.
All right, thank you. That concludes my inquiry on that topic. Does the state have any more dire on the issue of the death penalty?
We do not, Your Honor.
Nothing further, Judge. Thank you.
All right, thank you. That'll conclude your individual voir dire, Juror 752. You'll be escorted back to the jury room. We'll bring another juror in and we'll get through the rest and then you'll receive further instructions.
All right, what'd I miss? Anything good? Anything happening? Juror says he's no problem putting 12-hour days of trial and working at night. For 10 weeks? I don't know about that, man. All right.
All right, thank you for returning. This is Juror 791. We've got some additional voir dire I think we need to conduct as it relates to potential bias, and that would be due to information this juror has about the case from previous media. Some expression of concerns also about guilt. So the court wants to start there with bias questions. If the state would like to conduct any voir dire, I'll allow that, and then I'll allow the defense.
Morning. Morning. So I just wanted to ask you a few questions about some of the media exposure that you've had in this case. In
I'm
your
hungry. I need a
questionnaire,
sandwich.
you referenced some news reports and also some documentaries. Do you recall which documentaries that you watched?
The two that come to mind, one was from I think it's ABC 2020. And the other one was a Netflix documentary. I watched it once when it came out. I can't recall the title, but it was specifically about Lori.
And that's okay. On one of the questions in the questionnaire that you filled out, at the top of page 15, there was a question: could your knowledge of Chad Daybell prevent you from acting impartially in this case? One of the things that the judge is going to instruct you during this trial is that Mr. Daybell is innocent until the state meets its burden of proof. And the state would meet its burden of proof by introducing evidence during the trial. Nothing that you've heard thus far is evidence. Would you agree?
Correct.
Okay. Now, in answer to this question about your knowledge of Mr. Daybell, I believe that you were concerned that what you've heard so far would impact your ability to be impartial in this case. Are you concerned about that?
I've been going back and forth on it. Trying to gather my thoughts here.
Okay.
I feel like with some of my answers, and I kind of feeling I was probably contradicting myself unintentionally. I feel I have a fairly good grasp of being able to compartmentalize that I would not allow like the stuff that I've heard in the past, which has been quite a while, to affect my judgment.
Yeah. Okay, fair enough. In one question toward the bottom of page 15, you had indicated that even knowing that news reports and documentaries are biased, the evidence points to guilt. Do you still believe that up to this point?
I think I was trying to answer it, my mindset separate from me. So it was more the mindset of documentaries, or mostly documentaries. Especially the Netflix, if I have a predisposition of viewing the defendant as guilty. So it's more that I am aware and I acknowledge that what I was watching already had a preconceived notion of guilt.
Okay.
I don't think I put that across very well.
Okay. No, that's completely fair. And I really appreciate your honesty. I appreciate your honesty today and in your questionnaire. Would it be fair to say that this is something you're still wrestling with?
Thank you to Lynn for paying me $25 by Venmo. If I didn't thank you earlier, just saw that. Thank you very much. I think it was yesterday, but still appreciate it.
I would want to say no. I don't know, parts of me disagree with that. And again, with the compartmentalizing, viewing the evidence as it is. And again, not taking what this is about lightly. I don't want to presume guilt where there is none. I wouldn't want to subject any innocent person or anyone to anything like that.
Of course. And just one last question. Toward the bottom of the questionnaire on page 19, you had indicated that you had formed an opinion of Mr. Daybell's guilt and that you could possibly set it aside. Has that opinion changed today, as of today?
No.
Okay. Your Honor, I would move to excuse this juror for the exposure to the media that she's already had.
All right, so the question from the state for excusal for bias, Mr. Pryor, response?
Judge, I could just want just a couple questions.
You may.
And I appreciate your being honest. And what I'm seeing is that you're struggling with this issue. And you're not sure really how you feel. Would that be fair?
That would probably be fair.
If you're struggling with this, I think I told you, there's no wrong or right answer. What we're trying to accomplish is people who are, pretty certain about what they are. And if you're struggling with things, we all struggle with things. This is a big deal. So I don't want you to feel like we're beating up on you or being disrespectful to you in any way. In fact, I appreciate the honesty and how straightforward you've been about answering this. Thank you. Judge, I think I concur with the state. I just have concerns about something that she's just struggling.
Very well. I've considered the responses in the questionnaire also. Juror 791, absolutely nothing wrong with being interested in cases, following them, knowing about them. As you have mentioned here both today and in filling out your questionnaire, sometimes they portray things in a way that will cause people to form opinions. I do concur that I think the opinion's been formed here. So based on the responses, I am going to extend the state's motion to strike for cause for this juror based on bias. So thank you so much for your responses today, for taking the time to complete your questionnaire, for returning back, and the court gives you sincere thanks. Please drop your questionnaire with the bailiff on your way out. All right, we'll next have juror 823.
I had 823 is excused. Did I miss?
Oh, I may have. Oh, this is 823. I apologize. 823 was our juror who ran late, but I think is going to be returning maybe tomorrow. We'll talk with jury commissioner and I'll clarify that with counsel. So 909. All right, juror 909 has returned some indication in the questionnaire of knowledge of the case. So this is the time, juror 909, we want to discuss what you may know about the facts of this case and how that may impact your ability to be impartial. I'll ask the state at this time if you'd like to inquire more dire on that issue.
Thank you. Juror 909, looking through your questionnaire, it looks like you know a fair amount about this case. Is that accurate?
Not necessarily this particular case, but I knew about the other case that this deals with a little.
And are you referring to the case Lori Vallow?
Yes.
And did you follow that trial?
Not super closely, but there was enough talk about it that I heard stuff. So I heard something about the trial. I knew the trial was going on. I knew that conviction. I knew that.
And with what you did know about that, do you think that could in any way shape your opinion about the presumption of innocence for this defendant going into the trial?
I think it's possible, yeah.
I think in your questionnaire, when it asked if any of your possible exposure to news reporting or the city around this case caused you to form an opinion, you said maybe, and when asked if you could put it out of your mind, you said maybe I could try to be impartial.
I would like to think I could be impartial, but I can't help but wonder if evidence from the defensive side, from the side of the defense would have to sway me, and I know that that's not. I'm not sure that I can say that he wouldn't have to do something.
Sure.
Sway me.
So, and just and there's no right or wrong answers. We appreciate your honesty. So, Your Honor, based on that response,
They say there's no right or wrong answer, but then based on your answers, they exclude you, which makes it seem like there's a right or wrong answer now, doesn't it? Stop lying. There are wrong answers.
Judge, I would appreciate his honesty. I appreciate it. It's straightforward about your responses, but this situation.
All right, Juror 909, I've considered your responses to the questionnaire also. I do think that for you in particular, for this case, the best match as a juror, since you have knowledge of the corresponding case, which has likely influenced your opinion of the defendant in a way that would be fair. So nothing personal again. This is just the information we're going through with each juror to ensure a fair and impartial jury in this case. So thank you very much for filling out your questionnaire, taking your time to come back today. You're excused from your jury service, and please drop that questionnaire with the bailiff. Next juror will be 922. All right, thank you for returning juror 922. Just reviewing the questionnaire here, and I don't believe there was any expression of prior case knowledge here, nor concern necessarily about hardship. So as I understand it, with this particular juror, we would be reviewing questions related to the death penalty. Does the state have any further report other than that topic?
Judge, we actually do have one small question related to hardship.
Go ahead and start that in, Mr. Whitson.
Thank you, Your Honor. Sir, do you happen to have a question with you?
I do.
I might just invite you to go to page 20 of the question. And I would know before I ask the question, you did indicate that you did not feel necessarily a specific hardship if you were to be juror. Is that right?
That's correct.
Page 20, question 2, you indicated that perhaps you have some anxiety and that you would need legs so you can pay attention.
That's correct.
Do you feel comfortable just explaining that a little bit more?
Sure, and it came up earlier as well in regards to health issues. Both, I think physically and mentally, I prefer to have frequent breaks in order to process information better and so on. I think that I can perform just fine. I've done so academically, at least in my life, but I wanted to also recognize that I have those, I wouldn't even say shortcomings, just challenges that I face.
When you say frequent breaks, do you have any idea what that might require for you? Say that in the worst scenario versus the best scenario.
I think usually every few hours is fine. I know it's hard to judge simply because I have yet to be in a situation like this, and I can't necessarily, comprehensively predict how I might react to what is invariably digital information.
That's a very honest answer, right? Like, I've never had a situation like this.
The structure of, at least what I've experienced so far, is manageable.
So then just as a final question, in your estimation, as you said here today, you do believe that even though there'll be perhaps even distressing photos or graphic things that may cause some additional anxiety, you do feel like you can manage that and work it through that serve if you're chosen. Is that correct?
That's correct.
Thank you for answering the questions. Judge, I don't have any more questions.
No, Judge. Okay, thank you. All right, so Juror 922, the next topic we want to go through with you relates to the section of your questionnaire that, and do you have a copy of your questionnaire there? All right, we're on page 12, and that's the section 5 of the questionnaire, attitudes regarding the death penalty. Do you recall going through these questions last week and answering them?
I do, but may I make an amendment? Is that?
Yeah, I saw, I think I know where you're going with this, but tell me what you intend to change or correct on your responses, if you would.
It was more so at the time I was operating with the understanding that process was sort of one fell swoop. And you may correct me if this is incorrect, but it seems that it is the first responsibility of the jury to determine a guilty or not guilty verdict based on the evidence, and then to decide the charges.
In general terms, I think you're accurately tracking the legal process that would occur in this case, yes. Okay, and while we're talking about that, well, let me first let you know that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember that any penalty you're considering could be considered as if it is absolute and would be carried out in the case. So with that in mind, a few questions. I did want to seek a correction here. You stated on page 12 you oppose the death penalty, is that correct?
Yes.
Okay, and you've made some other comments we can talk about in a moment. On page 13, you circled under part 6 and option A, and I wondered if that is the one you intended to mark. That's the option that says, if a person is convicted of murder and the death penalty is requested, I will always vote to impose it regardless of the facts, law, and instructions given in the case.
I would say that's correct, yes.
That doesn't make sense.
I'm wanting to make sure we're tracking on impose versus oppose. So support or oppose the death penalty, in other words, for or against it, you said oppose, and you made some statements. That circle A is to always impose it, would be to give someone the death penalty.
I see where you're going now, and I did indeed circle the wrong option, just based off of an oversight in wording.
Okay, and I understand where that occurred. And again, I'm not trying to influence or have you change that. It's just a diametrically opposed view there. Would you do me the favor of reading through these options again under part 6? And if A is not what you intended, let me know which option you believe most accurately represents your feelings. And if you need to take a moment to do that, please don't feel rushed.
Certainly, thank you. I believe F would be accurate. That is to say, I'm strongly opposed to the death penalty, and I would have a difficult time voting to impose it. Yes, voting to impose it, regardless of the facts, law, instructions in the case.
Okay, I appreciate you making that correction on your choices there. So let me go back through some additional questions then. You stated that your views on the death penalty would not impair your ability to view the facts of the case impartially. Do you still believe that? Would you view the facts here impartially?
I do.
Okay. Do you feel, you next checked the box, yes. Do you feel your views on the death penalty would prevent or impair your ability to return a verdict of guilty on first-degree murder against the defendant, even if the state proved it beyond a reasonable doubt? So the question again, to summarize, would your views impair your ability to return a guilty verdict here?
At the time, I believe so. I believe, at least upon further reflection, I'd say, knowing that there are sort of two concurrent processes, I believe it's entirely possible that I might find a person guilty or not guilty based solely on the evidence of the case, but I would still be stubborn or staunch in regards to what I believe is appropriate punishment under those circumstances.
Okay. So moving on then, if you were to find or determine and vote for guilt, and after that, the court gave you instructions requiring you to next consider the death penalty, would you refuse to follow those instructions or be opposed to those instructions?
I believe I would follow those instructions fairly, but I also still feel that my moral position is more sort of irrelevant to the facts of the case, that it applies in all circumstances, and so it would be difficult to reconcile that with the consideration of the case at hand.
Okay, so given your feelings then, even if you didn't morally agree with it or want to do it, if I gave you instructions that the law said you had to consider it, would you follow the instructions and allow those instructions to supersede your own personal views on this?
I would, especially considering that I would be just one among a group of jurors. I would defer to the sort of knowledge and expertise and conclusions of the group over my own stubbornly held beliefs.
Okay, so what you're not telling me is that you would absolutely refuse to follow an instruction if it required you to consider the death penalty?
I would consider it, yes.
Okay, thank you for your responses. That will conclude the court's voir dire on that issue on jurors 922. Does the state have questions?
We do, Your Honor.
Go ahead.
Sir, we certainly appreciate your candor, and certainly you're right to have the position. Although the response you just gave the court does raise a bit of a tangential concern. You said that you, in your deliberation, if the court were to instruct you to consider the death penalty, that you would defer to the other jurors. If in fact, part of the court's instructions are that any verdict be unanimous amongst all the jurors, and you were instructed that you needed to come up with your own verdict, taking the influence and considering the perspectives of the other jurors, but that you needed to make your own decision. Is that something that you still feel like you could do? Could you make your own decision, follow instruction, and if actually appropriate, impose the death?
I believe I could. I believe it would also be, of course, strongly influenced invariably by the beliefs I hold now, but I believe I could.
When you say strongly influenced by the beliefs you hold now, perhaps could you flesh that out a bit more? Could you explain that some more?
Sure. I feel opposed to the death penalty in all cases, and so it is difficult for me to imagine trying to
He's gone.
Put myself in the shoes of someone
He's
who
gone.
would consider it fairly to
Yeah,
say
he's
that there
gone.
are circumstances where the death penalty ought to be applied.
Is it fair to say that you have some doubt, even though you would be willing, you would have some doubt that you could actually do that? You could actually set that aside and consider instructing. Is that fair?
I think if I'm being fair and honest with myself, yes.
Thank you, sir. Your Honor, based on this, and I do appreciate the juror's candor and his honesty, I think he's going to be very honest. But I do also think that he has a very strong opposition to the death penalty. He's included it multiple times in his questionnaire. It was that today. I think he's trying to listen to the court and potential instructions, but he just told us that he's not confident that he can actually set this aside. And I think based upon that, he ought to be excused for cause based on this issue, Judge.
All right, Mr. Pryor, I'll allow some more dire on the topic first.
Sir, I heard it a little differently. I heard that you'd be able to follow the court's instructions. Is that correct?
I believe I could, yes.
Okay, regardless of what those instructions are, right?
Yes, and also with consideration that the instructions are or will be, in the case of a guilty verdict, to consider the death penalty.
And please don't allow me words in your mouth. Just let me walk through this. I think you correctly identified, and the court recognized that. You recognized the first part of the process is determine whether there is guilt or innocence. But once the guilt or innocence is determined, then let's assume that there's a guilty verdict. That's not to imply anything with Chad, but let's assume there is a guilty verdict. At that point, the next process is for you to weigh whether you would vote for life in prison or whether you would oppose the death penalty. And what I'm hearing from you is that you, although you feel very strongly and you have strong convictions against the death penalty, you will still follow this court's instructions, and you will honestly and faithfully follow the court's instructions and consider both, even though you hold these strong feelings. Is that fair?
Yes.
Judge, I fair. Thank you.
All right, the court's considered these responses from the juror. Thank you for your candor in discussing the topic. The court does not determine here that these responses result in a finding that this juror would be substantially impaired or prevented from performing their duties based on an indication that they will follow instructions given by the court despite a strong or very strong moral opposition or belief against the death penalty. So the court will overrule the request to strike from the state, and that will conclude the individual voir dire for juror 922. So the bailiff will take you back to the jury room. We'll get through the rest of our jurors and give you further instructions before you're released today. Thank you. Let's next talk to juror 951.
This is all the process of what they call finding a death penalty eligible jury. It's like that you have to believe that you could impose the death penalty. And if you don't believe that, then you're not death penalty eligible. So, yeah.
All right, thank you for returning. Juror 951, we're going to conduct some individual questioning with you, beginning with some information that you have about this case or the facts. So starting there with the state, we want to discuss potential bias. I think that's the only issue for the other topic we'll get to based on, I don't believe any representation of the hardship. So the state can inquire on bias.
Thank you, Your Honor. Good afternoon. So in your questionnaire, you indicated that you had some media exposure to this case.
Correct.
About how much media exposure do you think you had?
When the case had eventually first started, a lot. To be completely honest, 100% a lot. Once it died down for a little bit, my thoughts died down. But after I had started my job with IDOC, it had gotten brought up multiple times.
So you had some conversations at work about it?
Yes, not like me individually having a conversation, but like hearing others talk about it. And so you hear people talk, and then you have your own thoughts that conclude to your head.
Just out of curiosity, what were your thoughts at the time?
I am a very forward person, and so I'm the type of person that I want to know the facts, and I want to see evidence, and I want to know the whole picture before I put pieces together to come up with a solution or the answer.
Sure. So did you form an opinion about the case and who might have done what?
To be completely honest, I want to say I had.
And was that in regard to the defendant, or was that in regard to Lori Vallow?
It was more of Lori Vallow that I had more of an opinion, and I had more of knowledge on than Mr. Daybell.
Okay. And do you understand that you'll be instructed that the defendant enjoys a presumption of innocence? That means that he gets to start this trial with a clean slate. Is that an instruction that you could follow?
Absolutely.
And you understand that as Mr. Daybell sits here today, he's presumed innocent?
Absolutely.
And do you understand that nothing that you've seen in the news or heard in the media is evidence?
Correct.
And do you understand that you can only base your decision in this case on the evidence by testimony from witnesses and exhibits that you get during this trial?
100%.
Okay. I have no additional questions for this witness. Thank you, Your Honor.
All right, thank you, Ms. Beatty. Mr. Pryor?
Sure. Ma'am, you mentioned that you had 100% media exposure. Is that, I assume that's a lot of exposure.
I suppose correct, yeah.
I suppose correct. You've watched Dateline?
When the case had eventually, or like first started, I was on top of it. I was very interested, not only from my previous career, but I also have always had the thought of becoming some sort of law enforcement, so I am always to watch anything that has to do with the news.
So you're an inquisitive person, that be fair?
Correct.
You're curious.
Yes.
And is that curiosity going to be creating a problem if you were limited during this trial to not looking at any of those things and only considering what you're hearing? And you are literally going to have to block out all the social media, all of your friendships. You're going to have to tell them we can't talk about it. And there's no right or wrong answer. Everybody, we're all different personalities, right?
Correct.
I imagine we're two different personalities. But it's a difficult thing to block out. You mentioned that you work at IDOC and then people started talking about it. You had to make an effort to sort of block that out, right?
Absolutely.
And it's a distraction, right?
To a point.
Okay.
I think from my background with IDOC and with my background from events that have occurred in my life, I'm very capable of putting things to the side and keeping things, I can't really say hidden, but like to myself, not to like discuss anything to anyone.
So if I understand what you're saying is that you, and one of the other jurors mentioned it was the term compartmentalize. In other words, I have a position, I've made have a view of what happened here. Okay, and then please bear with me. I've made a determination based on what I've seen up so far that this is what I think went on. But even though I've made a decision ahead of time, and I've taken the time, and you're an inquisitive person, and I've looked into things, and I've made a decision in my mind. But in spite of the decision I made, I'm going to consider the other evidence before I make my final decision. Would that be fair?
100%.
Okay. So in other words, you do have an idea and a position, obviously with Lori Vallow, right?
Yes, but I would, in my thought, I see is I want to see the evidence. I want to see
Right.
the whole story before I become sensitive to.
Right. In other words, you sort of made you have an idea what your position is. You said, all right, I made a determination of where I stand on this thing, okay? But at that point, before I make that final decision, I want to see the rest of the evidence.
Correct.
I want to be able to look at things and say, is my initial instinct and my personal feeling about this case and what I really believe happened, before I jump into that compartment, I want to confirm it with the rest of the evidence. Even though I've made a decision, I'm not going to say absolutely until I'm able to make the determination that my instincts were correct. Is that fair?
100%.
Okay, Judge, I have nothing else, and I move for cause in this particular case.
Response from the state.
And Your Honor, I believe that this juror has indicated she can set aside what she has heard. I also believe that she was pretty clear that her initial impressions in this case were largely based around Ms. Vallow. She indicated both sitting here today and in her questionnaire that she could set those aside and be fair and impartial. So the state would object to the motion to excuse this juror.
All right, I've considered the motion in this particular matter with this juror and the responses today, who's indicated a willingness to follow the court's instructions and consider the evidence and comporting with instructions already provided. I have not heard a opinion that I think rises to the level where I'm concerned there's been a shifting of the burden as we have with many other jurors here. So for those reasons, I am going to overrule the challenge at this stage and continue on with for this particular juror. All right, at this time then, Juror 951, the next topic we're going to discuss is the section of your questionnaire that's entitled Attitudes Regarding the Death Penalty. Do you recall last week filling out your questionnaire and thinking about those questions and filling out those responses?
100%.
And do you still maintain the same answers that you previously put in the questionnaire?
Yes.
Okay. I will advise you in this case that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. Remember, any penalty you're considering should be done as if it is absolute and carried out in this case. So with that in mind, I will first, just reviewing your questionnaire, see that you checked the box saying you would support the death penalty, and you also said you strongly agree with the death penalty. Is that your belief here today?
100%.
Okay. You are given a series of choices about what accurately represents the way you feel about it. You checked an option under 6B, and you said, I am strongly in favor of the death penalty and would have a difficult time voting against it, regardless of the facts, law, and instructions in the case. Do you recall selecting that option? Okay, so knowing that you support the death penalty, the next question I'm going to have, and it relates back to that answer, is do you believe that the death penalty should be considered or given in every case where a murder's been committed?
No.
All right, in your mind, when would it not be appropriate to be considered?
In my belief, it's more of trying to figure out the best words. For somebody to perform an act of murder, I believe that not only, like, to some degree, they should receive the death penalty, but then at some point, they should have the, like, life to imprisonment to where they have the, like, they have the thought process of what they did and what they have to suffer. And family members to the victim what they have to suffer. So it depends on the crime, or like it depends on the murder.
Okay. Going back to your option B, you circled here, you said you would have a difficult time voting against it, regardless of what the instructions were in the case. If you are given instructions, are you going to follow those instructions, or do you think your view on it would impair your ability to follow the instructions if the instructions, for example, said you are not to consider it in this case?
I will follow the instructions. I said earlier, and I will say it again, I'm more of evidence to be proven guilty, and that I guess that is the way I see it.
Okay, and if part of your duty as a juror is to not only determine guilt or innocence based on evidence, if then you are required to consider punishment in this case, and you're given specific instructions about how to do that, including options that may or may not result in the death penalty being imposed, will you follow those instructions?
Yes.
Okay, that will conclude the court's voir dire of this juror on that topic. I'll ask the state if they have any voir dire.
Thank you, Your Honor. So when the judge asked you about whether or not you would impose the death penalty in every murder, I believe you said it depends on the murder. Is that right?
Correct.
And by that, did you mean that you would consider the facts of an individual case before you decided whether you think the death penalty is appropriate?
100%.
So you would consider evidence that was perhaps presented in mitigation or to in favor of the defendant not getting the death penalty, you would consider evidence like that before you made a decision.
Yes.
And you would weigh that evidence, and you would weigh any evidence presented by the state to decide whether or not you would impose the death penalty.
Correct.
You would not necessarily impose the death penalty in every case. Is that what you're saying?
Yes.
I have no additional questions.
All right, thank you, Ms. Beatty. Mr. Pryor, you can inquire.
Ma'am, I'm just trying to clarify.
Can you have your microphone on?
Do now.
Thank you.
Thank you, Judge. I'm just trying to clarify some things, if you don't mind. Is it your position that at the present time, if there's a murder involved, your starting position is, listen, I'm going to impose the death penalty, but I'm going to include all of the evidence before I make that decision. So in other words, is it your starting position that, all right, and I'm not trying to imply whether Chad did this or not. Your starting position to say, all right, I'm going to vote for the death penalty unless I see something that convinces me otherwise. Would that be fair?
Yes.
Okay. So your starting position is the death penalty, and you're going to place the burden on the defense attorney to show that Mr. Daybell or anybody else who's convicted of murder should not get the death penalty. Is that what you're suggesting?
Correct.
Oh, okay. All right, thank you, ma'am. And Judge, I'm going to move for cause again.
All right, there's been a motion to strike based on those responses. What's the state's response?
Your Honor, this juror has indicated that she leans toward the death penalty, just as other jurors have indicated that they lean against the death penalty. However, she's also clearly indicated that she would follow instructions given by the court. And thus, I believe that it would not be appropriate to strike or to excuse her at this time.
Judge, may I respond?
Yes, go ahead.
Judge, the concern I have, with all respect to this, the preset notion that this is what I'm going to do, and putting the burden upon the defense to say, it's now your burden to convince me otherwise. I don't think that's what's going
All right, well, I've considered the arguments here. I think there's a different analysis that comes into play than the innocence or guilt analysis and presumption of innocence and reviewing the standard applying to whether or not a juror may serve in a case where capital punishment is being sought by the state, and the standard the court's looking at is whether or not their views are so strong that it's going to substantially impair or prevent them from serving as a juror and following the court's instructions. This juror has indicated a willingness to follow the court's instructions despite the fact that they may be opposed to that in their personal beliefs, and with that stated willingness to follow the instructions, the court does not find that this rises to the level of a for-cause excusal. So I'll overrule the challenge from the defense, and Juror 951, we will return here shortly for further instructions once we conclude our additional individual voir dire.
This is going to take longer than any other jury selection you've ever seen because it's a death penalty case. And it's a high-profile death penalty case at that. Well, except for the YSL trial. That doesn't count because that trial went on for multiple months. So, and except for that. But yeah, it's a death penalty case,
So
and it's a high-profile one.
next?
So it's going to take a hot minute, guys, to do a jury selection. Which is probably how it should be, you know, to be honest, from first principles. Yeah. And this is basically what you do. this is how this goes, just generally speaking. So as notability of the
All right,
case
thank you for
increases,
returning for this individual board juror 1004.
as notability of the case increases, and as the seriousness of the case increases, the classic solution to that process when it comes to jury selection is just to do more.
And this,
So it just takes longer. You're doing fundamentally the same thing you're doing when it comes to any jury selection. You just do more because of the seriousness / the publicity of it. So because this is death penalty, and therefore, definitionally as serious as it gets, and because this is extremely high profile, particularly in the state in question,
just a reminder,
it takes a lot.
Right answers here, and just want you to be fully honest, and
because you want to be thorough.
Everybody here will respect whatever your answer is.
So this is kind of like, this is just kind of the most extreme version of a very typical process. A lot more questions, a lot more examination of the questions, a lot more poking, a lot more prodding. It's just more.
It looks like you
in every possible dimension. I mean, you've heard about how many jurors they got, right? They were talking about juror numbers in the 4 digits, right? So I'm not sure exactly how they're counting. Presumably everyone they sent a questionnaire to. I don't know if they excluded some of those people just based on the questionnaire, but I'm assuming the numbers reflect every single person they sent a questionnaire to, and they were into the 4 digits. So they're taking their time.
So is it fair to say you haven't recently kept up on the case?
I have not, especially once being aware that we potentially involved with this research or listening to the news about it.
So I want to go over a couple of your answers with you just to see where you're at. Under 10D, it says, to be honest, it doesn't
also,
look
incidentally, for the same reason, when it comes to the Koberger case, it's one of the reasons I seriously suspect before the end it will be transferred. Because the town in which it's Moscow, right? Moscow, Idaho, I believe it's called. The town of Moscow, Idaho has something like 20,000 residents, most of whom are college students. And, so it just is, so you disfavor, the law, especially modern, disfavors transfer. We disfavor moving from one venue to another. But you look at Koberger and you're like, even if we do more, how can we possibly get it? How can we possibly get an unbiased jury? There just aren't enough people. So it's like, yeah, there's just not enough people to do more.
Just because we kind of talked about this with the bias earlier.
So we should probably transfer it somewhere else because we just don't have enough. We don't have enough people. So I'd be somewhat surprised if Koberger isn't transferred to another venue by the time it actually gets to trial. The quadruple college murders in a college town of 20,000 people, probably going to get a couple people's attention, I would imagine. So we might want to find a bigger place.
All the details of the case, from which ones I'm sure I'm aware of it.
Is 50 the number they're trying to get to? That sounds plausible that 50 is the number they're trying to get
This
to.
defendant has the right, a very, very important right to a presumption of innocence.
Your friend is juror number 3596? Yeah, yeah.
Every juror who sits on this jury needs to be able to give him a clean slate at the beginning. So if
the courtroom audio could be improved, man. This is pretty good courtroom audio, I have to say. We're not doing too bad.
Can you say without hesitation, with full commitment, you can set aside everything you've heard about him?
Yeah, I'm not sure what number they're trying to hit, but 50 isn't an unrealistic number.
The facts that
So if that was reported somewhere, that's probably a reasonable. That's a reasonable guess.
That's what we want. Thank you for being truthful. I'd
probably want to be a little bit more than that, to be honest, but it's just me because I'm paranoid. It's 50 is what they want to get to before round 2? Okay. Yeah, that sounds plausible. And then they want to reduce those 15 to 18 or 50 to 18? Okay.
Juror's honesty.
So they
Based
have
on his,
what? Essentially triple their needed
his
number
answer, he
in the pool?
to excuse this juror.
Yeah, it could be.
All right, from the defense.
And Officer, I really appreciate your
I go
honesty.
for 54 though, so I could get true triple though. But you know, I'll take that, I guess. Yeah.
Officer, I appreciate your honesty and that there is no wrong or right answer. You're well aware of that. But again, like
16, not 18. Yeah, I don't know how many alternates they're going to have. I don't know what the answer to that question is. But it's a death penalty case, and it's 10 weeks, so it would not surprise me if they had 18 jurors. That would not surprise me.
Thank you, sir.
All right, the court's
16 jurors, so you have 4 alternate jurors for 10 weeks.
Heard by the defense. The court
I don't know,
also
man.
concludes that
I
this
probably feel a little bit
stage
more
of
comfortable with 18,
proceedings
not
has
going to
been an
lie.
indication that based on pretrial publicity and knowledge of the
Yeah.
case, there's likely an inference of guilt. That
6
this,
alternates, yeah, that sounds a lot more
juror would be
plausible.
struggling with,
For a 10-week capital murder trial, yeah, 6 alternates sounds a lot more plausible.
Right. So
Yeah.
thank you so much for filling out your questionnaire and
Yeah.
returning today. And we will allow you to be excused. Please drop your questionnaire off with the bailiff.
Thank you, Your Honor.
Thank you.
Yeah. 6 alternates sounds like a good number. Hmm. For a 10-week trial.
So next up will be 1048.
In 10 weeks, I mean, again, it's a capital murder case. So they're going to give probably more time. I mean, you know, they're going to allow for a lot of testimony because it's capital murder. Again, just everything takes longer. You know?
All right, juror number 1048, thank you for returning for individual board hour questioning. The court's first going to request that counsel make inquiries as it relates to any previous case information, noting the juror has indicated in the questionnaire some knowledge of the case or related case based on media coverage. So I don't believe there's been an expression of any concern for hardship. So if the state would like to inquire on bias for the board hour, you can do that at this time.
Thank you. Thank you, Your Honor. The state doesn't have any questions in this regard.
All right, Mr. Pryor.
I can just help.
6-month grand jury asbestos trial? The grand jury really shouldn't take that long. But I wasn't there, so what do I know? I didn't get any matches from my speed dating, by the way. I just got an email while we've been talking, so that's sad for me. I thought there were a couple ladies there that I had some compatibility with, but I guess they thought differently, so very disappointing. Maybe next
Just
time.
briefly to confirm here, Juror 1048, you did say that you had heard of the defendant and what he was accused of due to media coverage. You also indicated you've not previously formed an opinion about his innocence or guilt. Is all of that accurate?
It is, Your Honor.
Okay, thank you for confirming that. Without further questions on that, then the next topic I want to discuss with you, Juror 1048, relates to your attitudes regarding the death penalty, and that is part of the questionnaire starting on page 12. Do you recall reading those questions and answering those?
I do.
And did you take, I know it was a long questionnaire, did you take the time to really think through those questions and answer them as accurately as you could?
I did.
Are the responses you made there still the same as the way you feel about things today?
Yes, sir.
Okay, I am going to advise you that it might be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. And please remember that any penalty you are considering should be considered as if it is absolute and will be carried out in the case. So with that in mind, you first in your responses stated that when you had the choice between support or oppose the death penalty, you checked the box saying you support the death penalty. Is that correct?
Correct.
You also had certain choices that, not necessarily your words, but descriptions of what you think or what is most accurately would represent the way you feel. And that's on question 6. You elected option C, and that reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still accurate as to how you generally feel about the death penalty?
It is, yes.
Okay. A final question I have then is, would you always be in favor of the death penalty in every case where a murder has been committed?
I don't think so. I think it would depend on the circumstances of the case.
Okay, and would you follow all of the court's instructions relating to the death penalty in this case if you were provided those instructions?
I would, yes.
All right, thanks for your responses. Moving to the state on that topic, is there any vote out from the state?
There's not, Your Honor.
From the defense?
Yes, Your Honor, just very briefly.
Very well.
And I always like definites. We can't always get definites in big statements. And I think you want to ask. You said, I don't think so. Could you expand on that a little bit for me?
What I meant by that is it really will depend on the circumstances of the case. I can't say that I would always favor it. It would just depend.
Okay. And I don't ever want to put words in your mouth. I want you to hear what your opinion is. That's more important than anything. Not the state, not my opinion or anybody else's. What I'm hearing is that I'm not leaning either way, the death penalty or life in prison. My decision isn't either one. It's a neutral decision, and I'm only going to make that decision after I have all the facts and all the information. Is that fair?
That's fair.
Would that be more accurate if there was a choice on this list in the middle that said, I'm neutral, and only after I hear all the evidence will I make that decision?
If that would have been an option, I would have selected that, yes.
Okay, Judge, I have nothing else. Thank you. I'll pass it.
All right, thank you. We'll have you return for some further instructions here shortly. Thank you for your patience today.
Thank you.
Okay, next up is 1057.
I'm still trying to figure out what my plans are for the eclipse. I don't really have a plan.
We are going to conduct some individual
that's
voir
exciting.
dire at this time outside the presence of your fellow jurors. The first topic we'll just get right to is relating to questions of bias. You do have
I
some
wonder if I could go to
prior
Bucky's and
knowledge of
watch it
this
there.
case,
That'd be cool.
and you've made some indications, including a statement that said the news makes them seem guilty, and that would include the defendant, and a few other statements. You also raised your card in one question about whether or not you may already have an opinion in the case. So I'll allow the jurors to question you on that. And of course, in this setting, you're allowed to more openly explain any detail of what you think you may already know and why you may feel the way you feel.
11:25.
So for the state, who's going to conduct court doc?
That would be me, Your Honor. Thank you.
Okay, Ms. Beatty, on it, bias, please.
Thank you. I want to talk a little bit about something that might be kind of painful for you that you referenced earlier, which was a situation with your brother-in-law. It sounds like he was burned at one point.
Yes.
And that you happened to be there. And
I took him out.
Okay. I don't want you to have to relive the entire story, but can I ask, is he okay now?
And this, I'm sorry to interrupt here, but if this is a topic you'd wish to discuss not in a public forum, we can do that, or you can discuss it in a public forum. It's up to you. Okay.
If I cry, I cry.
Okay. All right. Thank you.
And if you change your mind at any point and would like it to talk about it privately, that's okay. So he was severely burned, is that what you were saying?
Yes.
And did he have to get treatment for that?
He spent 6 weeks in Salt Lake and
and
then there's been residual issues.
Approximately how long ago was that?
It was over 30 years ago.
Okay. And you mentioned that that particular experience might make it difficult for you to look at some photos today or during this trial.
Yes.
Do you believe that your personal experience in this case would prevent you from looking at the photos, or do you feel that it would just make it difficult for you?
It would just make it difficult.
Okay. Now, one thing that you're going to be
What's Nate
instructed
doing?
on
I don't know. I've asked him, and he doesn't seem to want to put something together, so I don't know what
is
he's doing.
that as Mr. Daybell sits here today in this courtroom, he's presumed innocent, and that all of the jurors need to give him the presumption of innocence until the state meet our burden of proof beyond a reasonable doubt. Are you able to
You have to
give
drive up to
Mr.
Waco
Daybell that presumption of innocence?
from Houston?
Yes, I said I would definitely consider all evidence.
Okay. Now, specifically with those photographs, understanding that Mr. Daybell is entitled to a presumption of innocence, would you be able to set aside your personal feelings and experiences and evaluate those photographs and weigh them along with the other evidence that you received in this case?
Yes.
Okay. I would like to talk about some of the media coverage in this case as well, and I thank you for being willing to talk about such a difficult subject. You had mentioned that you had been exposed to some media in this case, and you had also indicated in your questionnaire that you would be able to put out of your mind what you have read and heard about this case and render an impartial verdict based solely on the evidence presented in this courtroom. Is that correct?
Yes.
Okay. Now, earlier, the judge asked all of the jurors if anyone had formed an opinion on Mr. Daybell's guilt. Do you remember that?
Yes.
And I believe that you raised your paddle.
I did.
Do you want to, would you be willing to talk about that with us a little bit?
I just, in my personal life, I've always been called honest to a fault. And I had a personal situation where somebody tried to get me to go do something that I knew was wrong. And if that person would have done that thing wrong, I would have turned them in. That's my issue.
Okay. So could you elaborate on that a little bit as it relates to being here today and raising your paddle?
Well, my friend wanted to go confront her ex-husband who had been a little leeway with her daughter. And she said, and I'm taking my gun. And I said, I am not going with you. And then if she would have done that, and I knew that, I wouldn't try to hide it. I would call the police and tell them.
Okay. So Do you feel that that relates to Mr. Daybell's case in some way?
Somewhat, yes.
Okay. And it sounds like that was a very difficult position that you were put in by your friend.
Yes.
But understanding, as we talked about earlier, that you have to presume Mr. Daybell innocent, do you believe you could set all of that outside of your mind?
I would do the best I could, yes.
Are you sure that you could do that? Just brutal honesty.
I probably am.
Okay, okay. I really appreciate your honesty.
Maybe I'll go up to
Your Honor,
Buc-ee's
at this
near
time. I think we have
Waco
to
and
do it.
camp out in their
Please,
parking lot.
Madam Juror for cause.
Okay. Mr. Fryer.
And ma'am, there
Near
is,
Enos.
as Ms. Beatty indicated, there's no wrong answer.
3.5 hours
And I
away.
actually have high regard for you
But
being so
I might do
very
it.
honest.
I think it'd be fun.
I greatly appreciate what, the fact that you've done so today. I'm for it. I think that's consistent with your character, that you speak the truth. So I greatly appreciate it all. Judge, I concur with the state.
Okay, I've considered the state's motion to strike. I'll sustain that. So juror 1057, based on your potential bias here from previous media exposure to the case, the court very much joins in with counsel in appreciating your service and coming in, filling out your questionnaire, taking your time today, being involved in this process. This will conclude your jury service. You may be excused, and please submit your questionnaire to the bailiff as you leave today.
Thank you.
You're welcome.
Okay, so if I go here.
All right, before we conclude then, we're going to take a late lunch. We're off the record for the remainder of the day. The court wants to meet with counsel for further questionnaire reviews, which we'll do this afternoon. I'm going to propose we start that up at 2 o'clock. Is counsel okay with that as a start?
I think we're done for the day, guys. I think we're done for the day. Because it sounds like after they come back from lunch that they're going.
Thank you, everyone, for the reminder. We are bringing the jury back in for cause, and we'll inquire whether or not they're being passed.
Yeah. Go up to Enos, Texas. 4 minutes and 23 seconds of totality.
So while they're going to return, is the state okay with a 2 o'clock start time for questionnaire reviews?
Yes, Your Honor, that should be fine.
At
All right,
1 o'clock p.m.
Very well.
Yeah, or 12:20 is when it starts. Neat. Okay, yeah, I can do that. I'll go up there on the 8th. I'll go up there and camp out at like Buc-ee's or something, or a park up there or something. It'll be fine. And get 3 minutes of solar eclipse in my life. All right, guys, I think we're done for the day, because it sounds like when they come back from lunch, they're going to be doing some kind of review relating to the questionnaire rather than asking more jurors. So how many jurors did we get through today? Did we get any? I'm not even sure that they actually asked if they're passing any jurors. Maybe they're bringing them in and do that now. Is there still, wait, hold on. Let's see what happens.
All right, having gone through the small group here, remaining are jurors 752, 922, 951, and 1048. We concluded voir dire. Does the state pass this small group for cause?
Yes, Your Honor, thank you.
Does the defense pass the group for cause?
Yes, Your Honor.
Okay, thank you.
All right, plus 4.
Thank you.
Very well. Ladies and gentlemen of the jury, the 4 of you, you have now been passed for cause, so we're going to continue to question additional small groups until we reach the necessary number of jurors for the attorneys to exercise their.
All right, we're up to 20, guys.
You will be returning for that process, and you'll receive further instructions from our jury commissioner, Randy Rutland, who will advise you when you do need to return. Very importantly, between now and the time you do return, please do not do anything to end up biased in the case by looking into the case. So don't do any kind of investigation into the case, follow the case on the news, try to refrain from speaking to anyone about any of the facts of the case. You are, of course, permitted to talk to people.
They estimate 2 weeks for impaneling the jury. Did they really?
About your potential
That's a long
service
time.
in this case to make those preparations, but no discussion of the details or discussions about the case so that you can maintain your impartiality, which you've demonstrated here today. So that will conclude your service for now. You will be returning. The bailiff will help you out for the day with your further instructions on when to return. And we appreciate your service to this point. But I'll please rise for the jury. Okay, we'll come back in for questionnaire reviews on the record, but outside of the public here for further review at 2 o'clock. Thank you, counsel, and we'll be in recess till then.
All right, guys. Yeah, so we're done for the day. They got some other work tomorrow, so that's cool. They got 4 more through today, so they're up to 20. And it sounds like they're trying to get to 50, so, well, they're averaging 10 a day, I guess. And so that would take 5 days, which would take the entire week. So we're here for phase 1. Yeah, I think so. We're phase 1 for the entire rest of the week. Sounds right. And then tomorrow, or apologize, next week, we're into phase 2, wherein they'll be doing more intense questioning on like a one-on-one basis to figure out if they want to pass jurors preemptively or not. And I don't know how many strikes each side gets, but I bet it's quite a few, given that it's a death penalty case, if I had to guess. So it could take quite a long time because they're going to probably go through them one by one in a somewhat tedious fashion. So yeah, that's where they're going. So yeah, about 1 hour per person. Yeah, something like that, I guess. That's one way of putting it. So you need 50 hours. Yeah, so maybe something like that. Yeah, that's probably about right. So that's where they're at. It just takes longer. So I guess I'll strike my stream for the afternoon because we're not going to have a stream this afternoon because there doesn't seem to be any more jury selection today. So we will delete the stream for this afternoon. All right. Is anyone streaming that I can send you to? Let's see. Laura, is streaming about Koberger. I could send you there. Is anyone else streaming? I guess I'll send you over to Laura, Okay, yeah, he just got started with a stream on Koberger at the top of the hour, so you guys won't have missed much on Koberger. So that should be fun. All right, guys, I will talk to you later. Hope you have a great one. Till later, my friends. Goodbye.